Good afternoon, everyone. Good afternoon. Welcome. Welcome to the House Judiciary Committee. I'd like to call us to order. We're going to have a briefing today from the Department of Juvenile Services. We will hear from the Juvenile Monitoring Unit with the Ombudsman's Office. We'll hear from the Juvenile Justice Commission. That's the abbreviation. It's much longer than that. And we'll hear from Department of Juvenile Services. And the order will be Thank you for that moment for a pause. I just wanted to make sure we had everything in order, and we do. So we're going to start with the Office of Correctional Ombudsman. We are getting slides up, but we'll go ahead and begin, at least with introductions. This is correct. We can thank Vice Chair Davis for having an ombudsman. And this is also a good opportunity to welcome our newest member, returning member, Delegate Susan McComas. All righty. Are we ready? Okay, so the only thing is I do need you to speak in the mic, if there is one. Yes, okay. Thank you and welcome for being here.
Acting Secretary Tolentino, Judge Davis. I am Yvonne Bradley Wilson. I'm the Maryland Correctional Ombudsman, and I am joined by Deputy Ombudsman for Juvenile Oversight, Marvin Stone, as well as our small but mighty team from the Office of the Correctional Ombudsman, where we function with transparency, accountability, impartiality to ensure fairness, dignity, and humanity and respect for those in the care and custody within the state of Maryland. Thank you for the opportunity to present today on the Department of Juvenile Services. I don't think our slides are being presented, so I'm just—
The slides are not up. Members, you will have it in your inboxes in just a moment.
Okay, thank you. We're going to discuss today Senate Bill 134. We're going to also talk about the blending of the Juvenile Justice Monitoring Unit into the Office of the Correctional Ombudsman and why that is important. We will discuss the oversight responsibilities and how it has impacted the work, specifically relating to facilities, programming, medical and mental health, and staffing concerns. While we recognize there are more areas of concerns, given the limited amount of time, we are going to narrow our focus to those areas. We will also talk about the Office of the Correctional Ombudsman and DJS collaboration and looking towards a brighter future. SB 134 established the Office of the Correctional Ombudsman in July of 2024. It created an independent and impartial oversight agency to ensure accountability and transparency across the Department of Public Safety and the Department of Juvenile Services. It also mandated for the successful blending of the Juvenile Justice Monitoring Unit into the Office of the Correctional Ombudsman. For those of you who may have attended my confirmation hearing, I drew an analogy between a tree with two branches, one for correctional oversight and one for juvenile oversight. While both sides function sort of independently, they also function together. operating with diligence, professionalism, focusing on ensuring those in the care and custody of both agencies are treated fairly, with dignity, humanity, and respect, under the umbrella of transparency and accountability, a common theme that you will continue to hear repeatedly.
Thank you, Madam Ombudsman. We would like to share with you some of our findings from the facilities. Physical plant, infrastructure, HVAC system, sanitation, pest and rodent infested facilities. BCJJC, among other facilities, there is a rodent infestation with students complaining about rodents and mice getting in the beds with them, graffiti in sleeping areas. The personal hygiene area for some of the students in their rooms, very unhygienic. And since November of 2025, we have not received adequate response in terms of how the rodent and pest infestation will be eradicated. Medical and mental health services. A lack of responsiveness to patient need and medical care. An example of which, while boots on the ground, during a visit to BCJJC, at the time, I was the ombudsman, now the deputy ombudsman, encountered a student who was sitting in his own waste and requested that that student be provided medical services while the nurses were sitting at their station. I had to file a complaint with the superintendent and get her involved. During that complaint, the youth mother informed the facility that she would come down to the facility and clean her son. And why should she have to do that when there are trained, qualified staff there to do that? He should not have been left sitting in his own human waste for that period of time. Lack of consistent communication with patient and off-ground care. There have been delays in providing the Office of the Correctional Ombudsman information when students are taken off grounds for serious incidents or when there have been fights or serious medical care. Nursing and bedside manner and patient care. On October the 8th, while this office attended a graduation for a high-risk student at Charles Hickey School, this office was informed by both staff and students of disrespect and unprofessional behavior by nursing staff at Charles Hickey. This office contacted the manager for that department to launch a complaint and receive appropriate information that it would be taken care of. Food services. Food services, the quality of food at Charles Hickey School, expired food still in the refrigerator, had not been discarded, certification across some DJS facilities, Safe Serve, which is a requirement to be able to serve food. Some of the staff that we encountered, certification was in question, and this is information that came to us from resources within inside of the department. Management conduct and food services. Specifically to Charles Hickey, we have received ongoing complaints from food service workers about unprofessional conduct from the food service management, gross profanity against those staffers, including being dehumanized and made to feel threatened and intimidated in coming to work. Programming. Excessive downtime on the weekend with a lack of sufficient recreation. As a result, students are encountered playing cards, and which leads to fights because they have not a lot to do. Lack of skill building and rehabilitation opportunities. Students need to have skill-building opportunities that when they are reintegrated with their families, that will allow them to be able to use these skills. Insufficient education opportunities for students who've graduated from high school. Students who have graduated from high school within the department need to have additional services and should not be forced to continue to going to school with students who have not completed their high school graduation. Staffing concerns. Insufficient staffing. Ongoing staff shortages. Staff are daily drafted. Staff accountability. Lack of staffing retention. One-to-one challenges. One-to-one staff should be better trained to work with high-risk students so that they are aware of what those students' issues are, and if they need help, be able to get adequate help. Excessive staff overtime. Excessive staff overtime pretty much so speaks to ongoing call-outs and staff shortages across the system. It's necessary for staff to be better trained and for staff to be held accountable in those cases where there are gross misconduct. Interpreter services. Interpreter services have been an issue ongoing. The current vendor have interpreters. In some cases, you have Hispanic students who have told ombudsman that the interpreter did not speak their language. We have had interpreters to leave for lunch and not return, thus leaving the student unable to communicate with staff and peers. Madam Ombudsman.
Thank you, Mr. Stern. OCO recognizes that there are many challenges. We view them as opportunities. We also recognize that these issues are longstanding. They did not begin with this administration. They existed long before the administration stepped in, and it will take time to repair and change. We also, however, recognize that a lack of transparency to OCO, a lack of recognition of OCO as the mandated oversight authority, or a lack of cooperation or collaboration will not resolve the issues, reduce recidivism, or make safer communities for us in Maryland. Because youth will not receive the services they need in order to return effectively into the community. However, if these issues are not addressed, the prior administration's failures will become this administration's failures. We are hopeful and we are optimistic. We have a unique opportunity, and I've shared this with both secretaries in the state of Maryland. There are roughly 23, 24, I think now, correctional ombudsmen across the country. We are uniquely qualified in the state of Maryland, and that we are an agency that provides oversight to both agencies. We in our office, we speak, all of us, collectively, regularly, and share our concerns. And so when we're working as a team, we want to work as a team with those that we provide oversight for. And when I say as a team, I mean collaboratively with transparency, expecting accountability. That requires effective services and effective supports. We're not going to always agree, but we need to operate in respect and transparency. Because if we do so, then that will ensure the dignity, respect, and humanity and fairness for those in the care and custody of the state of Maryland. Thank you for your time. If you have any questions, we welcome them at this time. I'm sorry. And I apologize for the confusion. We provided the slides, but you know, technology has a mind of its own.
That's right. Thank you, Ombudsman Briley Wilson. Thank you for being here. Thank you all for being here. Members, do you have any questions? Delegate Conaway.
Thank you for coming in to present. My question is about female hygiene products. I want to know when there's menstrual blood leakage is this treated as a violation or as a warning in general, to your knowledge, if you know?
To my knowledge, it is treated as a physical plant issue. If there is, are you asking me if there's a backup?
No, I'm asking you, is it treated as a violation or is it something that's just a warning per se? I'm working on a piece right now because in some of the correctional facilities that I've come across, if there's a leakage through on the uniform or on the bedding,
Oh, I see.
It's a violation with a reprimand. So
The best answer that I can give you is a case at WMCC where a young lady was locked in her room and her cycle came on and she was left sitting in her own body waste. That was very concerning for us. It was demeaning to her. She was embarrassed, and we made sure that she understood that it was not her fault.
did she get a violation for that?
No, she did not.
Okay.
I would like to add also to that, there has, I think, as I recall, been sometimes an issue related to receiving products.
Yes.
So I would just add that.
Okay. Thank you so very much.
I'm going to start with Delegate Phillips and then Delegate McComas.
Thank you, Madam Chair. First time I got to say that publicly at a hearing. Thank you. You've made a lot of observations, and I know you're early in your work. What I didn't hear were recommendations, and have you begun to make any recommendations to the to DJS?
We've made lots of recommendations in our past two reports, which we do have copies here if anyone has not read and would like to receive. There have been several recommendations specific to not only the issues discussed, but several additional issues. Yes.
What would you say are the priority items based on your observations and the recommendations, particularly around physical plant facilities?
So one of the things, when you talk about the rodent infestation, for example, we have received a response, and we have responded to that response twice now. And in fairness, the most recent response was only yesterday. The prior two responses, however, were in November and December, where we requested, the indication was that there was going to be expanded rodent, I guess, extermination services. Mm-hmm. So we sought clarification of what that looks like, and I don't have an answer for that, unfortunately. I'm sure they're working through something, and we recognize it takes time.
Delegate McComas.
Thank you, Madam Chair. I just have a couple of questions. When I first started, Hickey was supposed to be closed, and I assume it's not the new fancy Hickey that's still there. It's the old Hickey that was supposed to be closed. And I don't want to delay the committee and the other commentators, but my concern is how come it wasn't permanently closed? Because it was in bad shape 20 years ago.
I'm going to defer to Mr. Stone. He has more history.
I cannot answer that question. Maybe the acting secretary will be able to provide more information, but the program is, you're correct. It is still running. And like yourself, I have been around for the last 8 secretaries, and
Longer than I.
so it has, it continues to operate.
Wow. Have you all thought about, well, since you're dealing with juveniles and children, you know, I know that they have some prison programs where they have pets, you know, cats or dogs. Have you thought about, you know, obviously you've got to make sure that it's the right kids and, you know, and they like animals and they're not going to hurt them or anything. But maybe to get some animals, some cats in there that, you know, might like to have an extra dessert.
We are hopeful that that's a program that Acting Secretary Fox Talentino will bring back. That is currently in one of the programs, an animal, a dog that is considered a DJS employee. And that's Ginger up at the Backbone. And there were dogs in the other facilities, but they were removed under the prior administration. So we're hoping that they come back. The animals were a very vital part of the program. They were able to keep the students quiet when they got out of control or something was happening in the school. If they brought the dog in, it provided a relaxed environment. The students really enjoyed taking care of the animal, really enjoyed walking the dog. It was a very important part of the program at a number of different DJS facilities. But to my knowledge, the only dog that currently is left is Ginger, and that's at Backbone.
Well, the other question I had was, when I first got into the General Assembly, several of the delegates on Judiciary had gone to Missouri, and they fell in love with the Missouri model. And I you know, we never got into it because obviously there was other things going on, but I was just curious, have you had a chance to look at the Missouri model, and has it been as good as they thought over 20 years ago when they went? And one of them was Senator Zirkin when he was a delegate, as well as Carmen Amadori. She's since passed away, but also Delegate Tony O'Donnell, and they went to Missouri, and for some reason it was really good, and they came back and they were very excited about it. And certainly it just seems like this has been a problem for years and years and years, that we've never gotten our act together with the juvenile system. And I mean, it's institutionalized problem, from what I can tell.
So we have not. However, we would welcome the opportunity in collaboration with DJS to examine not only Missouri, but other effective systems.
Okay. Well, thank you very much, and you have a challenging job.
Thank you.
Thank you, Delegate
love it.
McComas. Thank you. Delegate Taylor?
Thank you, Madam Chair, and thank you for being here today and sharing the information that you shared. For some of us that are new and some of us not real familiar with the workings of this part of the corrections arm, how many DJS facilities are you talking about? Are we talking 1, 2, 3, or 4 that had these multiple violations? Is there one egregious offender? And then can I just go ahead and get them all out? Where are they, these facilities, and what makes Hickey different from the others?
Okay. The main facility is BCJJC in downtown Baltimore, but it is not the only one. It is the primary one that has been an ongoing issues with the physical plant, ongoing issues with rodents, ongoing issues with a pest. It is now, by today's standard, considered an old facility. Victor Cullen is the other facility where there are sanitation issues. Students there often complain about because of where Cullen is located, it's in a remote area. Students there are often complaining about the bugs that are getting into, during the summertime, getting in their rooms, getting on them. It is something that has been ongoing, and I do believe that was inherited by this current acting administration under Acting Secretary Fox Talentino. So it is by far at BCJJC the most egregious in terms of graffiti, in terms of the physical plant. Victor Cullen is an old facility. Hickey, the reason that where Hickey is concerned, Hickey's kitchen is the only kitchen that's not directly on site. The food is prepared on the grounds, but I believe that's the West Campus. It's prepared and then it's driven behind the detention fence. So where other kitchens, the other facility kitchens are pretty much so right there. So those buildings are old and in need of some care.
Many of the challenges also related to Hickey in terms of food services, they stem from management. I don't know what else to say there. They stem from management, continued issues.
Delegate Congolo.
Thank you, Madam Chair, and thank you all for providing the briefing today. It was very informative. Just a question to piggyback on Delegate Phillips's question. Are there any specific examples that you can give us of recommendations that you had put forth in prior years? I know you said that you have a report, but I just wanted to just get kind of a better idea of any specific examples.
You said in prior years?
Yeah, because you had mentioned that you had put forth some recommendations previously.
To this year?
Oh, and we can, if you have recommendations this year, newer, that's fine.
And if you could give me 1 second here. I should have had this out.
Need it.
Yeah.
That one.
So I can, I'm just going to reference some of the recommendations from our last report, which was in November of 2025. And since we spoke specifically about BCJJC, one of the recommendations there, we didn't speak about contraband, but that's another concern that we have in terms of providing a systematic way of ensuring that contraband, identifying how contraband is coming into facilities. That is an issue. So we did recommend that there be some an identification method for that. The department should consider a facility-wide security assessment and develop an action plan to prevent contraband from entering or circulating within the facility. We have many resources that share information with us. Okay. And so we try to protect those sources. Anything that comes to us is confidential. And so we don't, when we go back to the department and we share information, obviously we're not sharing the sources. And so when we make the recommendations, we really make them based on what we know. We're not speculating. We based on either what we observed or direct information that may come from staff directly, confirmed. Another example, the department should ensure all youth, regardless of faith, have equitable access to consistent and in-person religious services. One of the things I think Mr. Stone touched upon is while there are some services being provided for religious reasons, it's been a challenge with the Muslim faith. We have worked collaboratively, I might add, with the department to try to address those concerns and to try to identify services that we can, not we, but collaboratively, identify services that can be brought to the department to ensure that the young individuals can have, the youth can have appropriate religious services. Repairs and upgrades should be completed in a positive place instead of room to support positive youth engagement efforts. So giving youth opportunities to engage in a positive way. And let's speak to the infrastructure piece. because I think that's huge. And part of the challenge with infrastructure is there has not been a consistent, and I'm not blaming this administration at all, because this is not a failing on the administration. There has not been consistency in terms of taking care of the buildings that provide a home. We cannot forget, these are homes for those who are in the care and custody of the state. And, you know, we take care of our personal homes. Why wouldn't we take care of the homes of where we're housing these young people? We get our grass mowed, we change the light bulbs, we make sure we have extermination come in and control for pests, we paint. We do all those things regularly and with routine. It should be the same. And I know some of those things are beyond their control. It's, you know, a lot of it is budget related, and we recognize that.
Okay. All right, thank you. I actually started my career in 1998 in a juvenile detention center. So they used to call me Joe Clark back then, if anybody's familiar with the movie Lean on Me. So thank you.
I
I appreciate it.
commonality. I also worked with DJS in Virginia.
All right, thank you.
Thank you.
Great, thank you. Delegate Valentine.
Thank you, Madam Chair, and thank you, Madam Ombudsman and panel. I represent both Frederick and Washington counties, so I'm very involved in this process. Victor Cullen is in my district. I visited. I thank the department for allowing me and Delegate Boucher at the time to do that. Very familiar with the complex in Hagerstown, and so thank you for this presentation. My question revolves around reporting of situations or concerns. Had a situation this past summer in which a family member of an incarcerated individual was trying to get some resolution to a family member in a facility. And there was a pretty good lag time. In fact, I was looking at the emails. It took about 6 to 7 weeks to get a resolution. And mine is more, how can we kind of steer those individuals? So a constituent reaches out to one of us. Do we go directly with your office, DPCS? How do we get them where they need to go to get this matter resolved in a timely manner?
Thank you for that question. So first of all, we are excited that we now have a website. So that's one option. We also have it's an 844 number, I think. So they can contact us through the 844 number. We also have emails established for juvenile oversight and correctional oversight. That's another option. We're in the process of procuring a case management system, which will also be a methodology for creating complaints. And then within facilities, obviously, when we are in the facility, and you office, you know, anybody can reach out to us. We welcome that through the emails. And then within the DPSCS facilities, we have mailboxes that we have the keys to exclusively. And so if I puts a complaint in the box, then it comes, we check the mailboxes. We have had that discussion also with DJS in hopes of creating something similar with them. Lastly, on the DPSCS side, we are currently doing a pilot program with the ViaPath tablets, whereby IIs can file a complaint through the tablet. We hope to expand that in the coming months.
So there's multiple ways for an individual who's incarcerated, and in my circumstance, it was a family member who was outside that can do it, some of the other methodologies in which you just explained.
Yes, they can email us, they can call us.
Okay.
We have taken emails and contacts directly from legislators as well.
And that's how we eventually did it. We reached out directly, and it was resolved through DPCS. I just wanted to make sure we were doing it the correct way.
Absolutely.
To make it as most time effective as possible.
So I will say this, though. The work we do is confidential. until we report it. And so if someone shares a complaint with us, we let them know that we're going to go to the individual that is, for lack of a better term, the alleged aggrieved party. And if they want to know what occurred or if they want to update, that's how the communication occurs. And part of that is, you know, even if that individual signs a release of information, the challenge with that becomes we can't control how that information is then disseminated by that other individual. So it's all about protection and safety.
One last question, Madam Chair. Are you currently, you've mentioned a box, are you in every facility or are you just currently located in one facility at this time?
So we're in all Jessup facilities, and we're trying to determine how best to proceed in expanding to other facilities. What I will say to you is we look at the complaints that come from all facilities. We're not here, you know, everyone in our office, we've been very strategic in our hiring, and we are there because we want to be there. Every single person. I am proud to say that. And so it is hard to say, oh, nope, that's not a focused facility. I'm putting that down. We don't do that. And so especially if it's a medical issue, an issue where there could be some safety concerns, then we try to address those in some manner. And so that doesn't mean given the volume, every complaint is not going to be addressed. And we're just now on the correctional side, becoming fully staffed. We're not quite there yet. We're a little shy of one person right now. But so we're just getting up and running. It's been a process of running the ship by building the ship. So
Understood.
yes.
Thank you.
Thank you for that question.
Thank you, Madam Chair.
The Vice Chair.
Thank you, Madam Chair. Thank you so much for the presentation. I want to follow up on one of Delegate Ballantyne's questions. Now, you have, how do you refer to it, a designated facility. That was your initial charge, was a designated facility. And you mentioned that you get complaints from all different facilities. But what's the difference between your job at the designated facility and how you're able to handle the other complaints?
So the focus facilities, the legislation's mandated that the focus facilities would be the Jessup region. And so for the first year, that's where we have focused. Again, not ignoring the other facilities, but let me try to give an example. First of all, we ask that incarcerated individuals exhaust all internal remedies. We do not want to interfere with the work of the Department of Public Safety and Correctional Services, or the work of DJS for that matter, right? And so if a II has filed a grievance and it's not been resolved, we're not here to come in and interfere with that process. We are here to address issues that, you know, are wrong, maybe, for lack of a better term. However, there are exceptions to even that. A medical issue, for example, if someone has an emergent medical issue that is not being addressed, then we're going to address it. We're going to reach out to the provider, Centurion, and we're going to say, why is this not occurring? And so there are exceptions. Now, back to your question about focus versus non-focus. The focus facilities were the Jessup regions. But when families and IIs and advocacy groups learned of this office, we received complaints from all over. And it required explaining and educating individuals on what the legislation stated. And so that's what we've taken the time to do. Some people are very understanding, some not so much, and I understand why. If it were my loved one, I might not be as understanding either, so I understand. And again, if it were issues even in non-focused facilities, I can give an example. You know, there was an individual in a facility, non-focused, that had dental issues, that teeth removed, was not able to eat, not able to drink, and wasn't well, I shouldn't say drink, wasn't able to eat, wasn't receiving proper nutrition. A family member reached out to our office, and I knew that was something I could solve immediately. It was not like to say, oh, that's a non-focused facility, did he file a grievance? I wasn't gonna do that. It literally took me 10 minutes. She was in my office, so she's saying that because she was in my office when I did it. And so something like that, we're not gonna ignore that, because that is about, again, someone's dignity, someone's respect, someone's health, and their safety. And that's an easy fix. So I hope I answered your question. I think I did.
Thank you. And our Juvenile Subcommittee Chair, Delegate Woods.
Thank you, Madam Chair. Thank you to our Ombudsman and Deputy Ombudsman for your presentation. I think you kind of touched on a lot of what I wanted to ask. My specific concern, I'm hearing of some extremely egregious challenges that are taking place, and I heard my colleague, Delegate Phillips, ask the question about the recommendations. My concerns are, and you actually just touched on it, things like the rodent infestation, the unhygienic services, the food insufficient food, and things like interpreter services. They seem to me like those are extremely important, and that in the end, if they are not addressed, they can impact the life, the health, the well-being of the individuals, sometimes irreparably. And so my concern is, while you say that there have been recommendations, what have been, because some of these things for me sounds like if you got rats crawling up in somebody's bed, that's urgent, right? That's emergent. We need to be addressing that. What are the barriers that are preventing some of these things that to me are urgent or emergent? And I'm not happy with hearing financial limitations. What are the barriers to not addressing these that are being provided?
I will say to you that food insecurities, for example, is a big problem for many of the young people who are being cared for within the department, and also their food trauma. And when I say food trauma, some of these students are for their first time getting 3 meals a day. And thank you for saying that about the barriers. Food should not be ever used as a weapon against students. There have been cases when individuals knew that the students were hungry, and to punish that student, food was withheld. At the time when I was the then monitor, which we now call Assistant Ombudsman, assigned to Charles Hickey School, I had to address with the administration there, who actively addressed it, staff behavior toward a student. The student was hungry, and staff used food as a weapon to punish that student. We understand, I'm a clinical person, so we understand that if children are fed and they're getting what they need, they're less likely to act out. If you show an interest in making sure that they are provided for, they're less likely to act out. So the barriers are making sure that staff understand what are clinical issues for these kids. If food is a clinical issue, like, for example, at the Hickey shelter, I made a visit. The young man said, I can go into the kitchen? And the staff said, of course you can go into the kitchen. He was afraid to go into the kitchen to get something to eat. It angered me. And it angered me from the standpoint because that's what it's here for. It's for him. So I said to the staff, let him eat as much as he wants to eat. When he realizes that the food is not going anywhere, then he will relax. But until then, let him have what he wants to have. He was sending a clear message that at home, food is a clinical issue for me because there's a lack of it. So let him eat. So there are barriers. The barriers can be in terms of staff training. It could be in terms of the staff not having enough information about specific youth backgrounds in order to provide the care and treatment that they need.
We instituted a meeting with food service staff that's under the prior administration. In that meeting, the goal was to have administration from DJS or leadership from DJS, our office, and the input of the young people. That meeting was discontinued, not by us. And hopefully, maybe it will be reestablished in the future. But it was to address some of those concerns.
Sure.
Still, the concern was, that I also articulated, was things like the lack of medical and mental health services. What are the barriers? The lack of getting someone to come in to address the rodent and infestation issue. What are the barriers? Do we have any identified barriers based on recommendations or any other input?
I think that's a question for the acting secretary. I think that's a question for the acting secretary.
Thank you. I have perhaps 3 questions. And the lead-in with that conversation you just had is probably, it's right on time. So I wanted to know, with respect to what, if any, frequency do you have collaborative meetings with respect to DJS?
I have a monthly meeting with the acting deputy secretary. We've established a monthly meeting so that we can be collaborative with the acting deputy secretary and the 2 executive directors. We also have a standing monthly meeting with the Office of the Inspector General for the Department of Juvenile Services, that we can be collaborative to talk to them about incidents, restraints, investigations. And we have had, I think, some meetings with the current administration, and we agreed at our last meeting with the acting secretary on December the 17th to establish meetings every 6 weeks, I believe, so that we will continue to operate with collaboration and make recommendations.
Okay, I appreciate that. I don't know if 6 weeks is frequent enough. From what we've heard today, I think that there has to be an intentionality, is what I'm hearing. So I would kindly urge more frequency, and I would kindly urge even, almost a chart and a checklist where we go down. And I know that our members, and for this committee, would love to have a frequent understanding of the status of some of these things that came up in the report. I know that that we all need to have that. We need to have it because we need to understand that things are getting better. And if they're not getting better, we need to understand why, hence the reason subcommittee chair was asking those questions. The other thing I wanted to ask is, with respect to any level of oversight and review of those recommendations, that's where I was going with that frequency. So the recommendations get made, there has to be, and I'm sure there is, some level of review of those recommendations. This is where I'm going again, that I want, I think some type of status report as to how that is going would be helpful as a recommendation. If it already exists, great. If it doesn't, this is just a friendly recommendation. And then last, if you could actually give us the link or the URL for the website, because I'm pretty good with doing my research while I'm here in a briefing, but I was unable to find it. And then with that, I'll give you a minute to get that. But what I'd like to tell the audience who is online, this is not, we have sent out no invitations for digital responses or digital input. So I strongly, ITO, if you're listening, or anyone else, please do not use any link that you might have received to testify. This is not an open hearing. This is a briefing that we are getting specific information that we've asked for as a committee. The second thing I want to mention to the members, I'm going to step away for a moment. Actually, it's going to be for a little bit longer than a moment, but we are going to indoctrinate our vice chair for her first sitting in the chair role. I urge you to give her the level of respect that I know you all will, and I'll be excited when I come back to hear how great things were. With that said, if you could answer the website question, and then
Yes,
we'll bring
ma'am.
up Judge Davis.
It is it's oco.maryland.gov.
Great, thank you very much.
Thank you.
Thank you.
Yes. Yes, it is.
Okay, if there are no other questions for the Office of Ombudsman, we'll move on to Judge Davis. No other questions? Thank you. Thank you for coming.
Thank you.
Welcome, sir.
Sir,
You may begin.
your PowerPoint.
It is.
Do you have someone to press the slides for you, or do you need someone to press the slides?
I'm sorry.
Do you have someone to do the slides for you?
Can I do it?
Yes.
Great. Perfect. Ready?
He's offered to do them himself.
I'll do it.
You are? You just click.
Thank you. Good afternoon,
Good afternoon.
Madam Chair, members. My name is Andre Davis, and through the joint appointment of the governor, the president of the Senate, and the speaker, I am privileged to serve as the first chair of the Maryland Juvenile Justice Reform and Best Practices Commission. I'm delighted to have been invited here today to give you a briefing on some of the commission's work. I look forward to answering any and all questions you might have. And by the way, I want to wish you a successful and satisfying legislative session for 2026. The work you do impacts all of Marylanders, as you well know. And so we are all pulling for you. The commission, I'll start with just a very, very brief overview of the commission itself, and then move into the immediate issue of focus for today's briefing, and that is the commission's first substantive recommendation on the issue of adult charging. The commission was, as you know, created in the 2024 legislative session, consisting of about 27 members, with about the broadest array of stakeholders any subject matter commission Maryland has ever had, I can imagine.
We have law enforcement, we have elected officials, we have appointed officials, we have stakeholders from the victim community, we have stakeholders from the expert child welfare community, we have lawyers, we have public defenders. It's just a remarkable array of people, many of whom, by the way, were familiar with each other by virtue of their earlier work on the commission's predecessor, if you will, entity, the Juvenile Reform Council that existed from about 2020 through about 2022. Much of the work that this commission will do will be follow-on work that was very successfully initiated by the earlier council. We quickly organized ourselves to grapple with the more than 25 mandates that are contained in the statute that created the commission. And in that organization, we've come up with 5 work groups, generally organized around themes. I must confess that as the chair, I took it upon myself to most respectfully amend your statute. What I mean by that is I have to say I was a little surprised to see not a word in the statute about prevention. And so at our first meeting, I declared that there would be a work group devoted to prevention. We don't want children coming into the juvenile justice system. As much as we want to do for them, once they are system involved, part of our work must be focused on keeping them out of the system. So I'm very humbly but happy to have done that. So we issued our first report in October. We will be meeting approximately 9 times a year, some in person and some remotely. And I have to tell you, in this first year or plus of our work, I could not be more pleased with the collaboration, the mutual respect, the mutual support that we have gotten from each and every commissioner. Each commissioner serves on 2 tasks, on 2 work groups, and we've organized ourselves, including a steering committee of the 2 co-chairs of each work group. So we have an organizational structure that we think will work well for us. As you will recall from the statute, there is no sunset. Each commissioner serves for a 3-year term, and we expect at this point in time to continue the work that you, our legislative and executive branch authorities have given us for as long as it takes to make Maryland a model, a national model in juvenile justice operations. So our first substantive recommendation contained in our October 1st report last year had to do with automatic charging of children in adult court and the related issue of children in adult detention. Now, this issue, many of you are aware, is not new. In fact, if you go back actually to the very beginning of society's recognition that for all of the really terrible, harmful things that children do, and there's no doubt about it, unfortunately, deeply traumatized children, often enmeshed in poverty, often enmeshed in dysfunctional families, often in the grip of adverse childhood experiences that have absolutely tormented their lives. There's no question that these children are capable of and do inflict grave harm on identified victims. We on the commission will never, ever overlook that, diminish that, or fail to attend to that. But in spite of all of that, we believe, and I think you believe in the legislature of Maryland, children are children. Children are not defined by what they do that inflicts harm. They're defined in many other ways, but that's not how you define children. So if you go all the way back to when society first realized from a legal, a clinical, a policy perspective that children committing what would otherwise be terrible felony offenses and others must not be treated as if they are adults. As early as 1977, here in Maryland, our Court of Appeals struggled with, as did this very body, this General Assembly, struggled with how to strike the balance in bringing accountability and responsibility to children who commit offenses in contrast to how we treat adults. And the struggle has continued over these many decades. And what we see here, it's almost like low-hanging fruit. People ask me, well, why was this issue of adult detention and automatic charging the first thing that the commission tackled? Well, one answer to that is, as I say, not to diminish the importance, but it's low-hanging fruit. It's been around so long. We've talked about it so much. And the plain fact of the matter is, members and Madam Chair, the plain fact of the matter is we know the answers. We know the answer to should we be funneling so many children into adult court? And the answer is no. And it's been no for a long time. And so what our task force on system coordination and processes undertook very successfully was to bring together in its report, ultimately adopted by the commission itself, to recommend that automatic charging of children in adult court finally be dealt with under the laws of Maryland. And there are several reasons for that. They're listed here. Funneling children into adult court exposes them to harmful, developmentally appropriate conditions because Maryland doesn't have designated juvenile detention facilities for most of these children. They are going into adult confinement in adult institutions. And the reality on the ground is that despite clear, unambiguous federal law on which much of our funding depends, children are not being appropriately separated from the adults in our local jails and detention facilities, despite the mandate of federal law. It gets worse than that, though. If it can get worse than having children locked up in proximity to adults. It undermines public safety, what we're doing now. And it drains resources. It risks adverse action by the federal government, and it's just bad for the children. So the Juvenile Justice Delinquency and Prevention Act prohibits holding children in adult facilities beyond 6 hours when they're arrested and sent there. And so I'm not going to bring you too much into the weeds. Most of you, I'm sure, either already are familiar with this material, and you will certainly better inform yourselves after today. But the fact of the matter is, Maryland's detention of children in adult facilities in violation of federal law because of how long they stay, because how long it takes for a judge to even review the circumstances of that detention, is so out of whack with every other state in this country that when the feds compiled their statistics about compliance with the Juvenile Justice and Prevention Act, Maryland's statistics are excluded from consideration in calculating averages and means nationwide. I ask you to just reflect on that for a moment. This state, alone among the 50, has such terrible statistics when it comes to how we are handling children detained in adult facilities that the experts at the national level won't include our statistics. That's reason enough right there, isn't it, to take urgent action. There's more. The truth of the matter, the plain truth of the matter, is that something between 83, 84% and 86, 87%, it's a small range. And there's, among some, there's sort of some skepticism about this statistic. But somewhere in the neighborhood of 86, 87% of the children in Maryland who are funneled into adult court through automatic charging under our law, 87% of them never come out of the system with an adult conviction. So I ask you again, reflect on that for a moment. 8 out of 10 children subject to automatic charging and therefore going through the bail system and seeing a district court commissioner instead of a judge. 8 out of 10 of those children, those hundreds of children in Maryland, 6 months later, 8 months later, 10 months later, a year and a half later, however long it takes, either for them to get through the entire adult system or referred to juvenile court, which is what mostly happens to these children. 8 out of 10 of them don't come out of the system with an adult conviction. So you have to ask yourself, wait a minute, we're sending 8 out of 10, more than 8 out of 10 through this process that the law says, for whatever reason, the nature of the crime, the age of the child, whatever it is, we want this child to spend 2 months, 4 months, 6 months, 8 months, 10 months, a year and a half in the horrible conditions of the adult criminal justice system, where retribution and punishment, regrettably, in my humble opinion, but retribution and punishment is the coin of the realm in the adult criminal justice system in this country. And look, I was a prosecutor. I respect our prosecutors. They have a hard job. I think after police officers, they have the hardest job of all, because they hold so much power, so much unreviewable power. And by the way, one of the foundations of prosecutorial authority and practice, state and federal, is that you always charge the highest level crime that you in good faith believe you can prove. That's not to do that, as a prosecutor, state or federal, elected or appointed, amounts to prosecutorial misconduct. It's a harsh reality. So these 33 laws that Maryland says are so awful, the consequences are so awful, and at least through implication, the children who get caught up in this activity, whether it's a 15-year-old under the influence of a 18-year-old, we want prosecutors bringing their traditions, their ethos, their training, their policy, charge the most. And I got to tell you, a number of those offenses in this list are attempt crimes. And I got to tell you, in all honesty, any prosecutor who can't turn any serious criminal act into an attempt at something is not doing their job. I don't mean my comments to be criticism of prosecutors. Again, I reiterate, it is the prosecutor's job to charge as much as possible, go for the maximum sentence, at least at the beginning of the case. Because admittedly, the prosecutors don't know everything they're going to know about the case at the beginning. So it's hard charging, it's retributed, it's focused on public safety almost exclusively. That's the prosecutorial mindset. So I understand why prosecutors in Maryland uniformly, I haven't met one yet who said about our policy recommendation, go for it, commission. You know, we have law enforcement on the commission and indeed on the work group that developed the information that went into our policy recommendation. And they opposed it, and we all respect their opposition to it, and you're going to hear a lot of opposition as we go forward. And we respect that. But I got to tell you, the most that I have heard from those who think we got it wrong in this recommendation, and they'll speak for themselves, I don't claim to speak for them, but what I hear is, we don't trust the data. You don't trust the data? Well, we have data from the Vera Institute. We have data from the Department of Juvenile Services. We have data from the Governor's Office of Crime Prevention and Policy. We have data going back 5 years, 10 years. And at the margins, as I said, maybe it's only 82%. Maybe, depending on how you count, maybe it's as high as 88%. And we're soon going to get data, so I'm told, from the Judiciary. And there is no reason whatsoever to believe that any additional data from anywhere, anybody, will undermine the ineluctable conclusion that we're channeling more than 80 kids, 8 out of 10 kids into the adult system to suffer through their time in that system, only to come out in juvenile court or with charges dismissed. Now, I know I'm over my time, so I want to be respectful both of your time and others who will address you. But the truth of the matter is, it's time for a change, and the commission has provided the compelling evidence by synthesizing all of the evidence that's been out there all these many years to make the case for, one, we should comply with federal law because we're required to, and it's the right thing to do. And the way to comply with federal law most urgently is to make a change to automatic charging. And let me close with this. Changing automatic charging, and you all know this, forgive me, but it needs to be said, because people get kind of strange ideas, doesn't mean children won't be prosecuted as adults. Doesn't mean that at all. What a change to automatic charging will do, among other things, is that it will express what I hope we all share in this state, is the trust we have in our judges. Because what a change in our current system would mean is that a child, many of these, more than 8 out of 10 children who are going into the carceral system, the retributive, punishment-oriented system, right at the beginning, where there are very few off-ramps. You know, if the public defender has to file a motion for a reverse waiver to get that child out of adult court and sent where the child, many of them, belong, which is in juvenile court, where they can have services, access to family, access to the community, treatment, interventions. So the public defender's got to spend the time and the money to develop clinical, expert, holistic, family-oriented, dynamic evidence to convince a judge to send the case to juvenile court. And they've been successful at that. It's been pretty expensive. That's why only about 2 out of 10 children who go into the adult system come out with adult convictions. And by the way, many of them, and this is a truth on the ground, no small percent of those children who do end up with adult convictions plead guilty. Why do they plead guilty? Because they get offered a plea agreement, which becomes a get out of jail tomorrow card. And you keep a child in adult facility long enough under those conditions, and even where the public defender says to the child, do not take this plea agreement, and it happens. But of course, it's not the public defender's choice, it's the child's choice, informed by family. So we need to do better. We need to trust the judges who will be charged under a change in the law that we recommend. A judge will hear whatever evidence, argument, whatever persuasive proof the state's attorney in each county and in Baltimore City can offer to a judge that we, again, presumably respect. They have taken an oath to do what's right in the interest of justice. Those judges will make decisions about which children go into adult court in accordance with the law that the Maryland Supreme Court has really filled in the gaps. Our Supreme Court has told judges, instructed judges how to make that decision. The factors that you take into account, what you consider. And no doubt there will be judges who will say correctly, frankly, who will say correctly, having considered all the factors that the Supreme Court and the General Assembly have told me to consider, this child, this individual child right here, the child seated before me, can't benefit in juvenile court. So I'm sending their case to adult court. We can live with that. Of course we can live with individual determinations of who this child is, not just what the child did, let alone what the child is alleged to have done. Remember, nobody's been convicted of anything. There are allegations. We need to trust the judges to do what they are sworn to do, just like prosecutors and all of you are sworn to do, among other things, protect the public, but to also do right by children. So, again, I apologize, and it really is a sincere apology for taking far more time than I told I was allotted. So I'll stop there. We're going to leave the slides, which the slides are simply a walk through our excellent 11-page report, which if you don't have, I will see to it that you actually have it in hand. I encourage you and know you will give that attention, and I absolutely welcome any and all questions that I've hopefully left time for from you.
Thank you so much, Judge Davis. We are going to have Delegate Boucher first. Question, Delegate Boucher?
Thank you, Madam Chair. Wow, Chairman, what passion and genuine commitment to this subject. I'm the member of the General Assembly who was charged and convicted as an adult while juvenile, so this subject is very personal to me. I think the existing policy is counterproductive, and it shows up in the expenditures with these children as adults. Is there any research out there that shows incarcerating juveniles with adults increases their likelihood to perpetuate and become career criminals?
Delegate, there's actually a word for it, and the word is criminogenic. That which is intended to reduce criminal behavior and recidivism, but that has the opposite effect, is criminogenic. And yes, there are lots and lots of studies, peer-reviewed analyses, just thousands and thousands and thousands of pages and web material that show that treating a child, even, by the way, even a child who already has an adult conviction, even a child who has an adult conviction already, will more likely than not, and some of the studies say way more likely than not, will result in increased recidivism as opposed to doing nothing or treating that child in juvenile court. And by the way, and thank you for your service, Delegate. The courts and this body actually in the 2022 statute recognized that. One of the things that statute did was to say that you have to reduce the period of probation. You reduce the period of probation. In other words, lessen the criminality features of treating juveniles. Another thing it did, and there was a recent case on this, the Court of the Intermediate Maryland Appellate Court applied that statute, by the way, retroactively. So there was like, you can't violate someone for violation of probation for technical violations, okay? And there was a case a couple of years ago where a judge found a technical violation, but nevertheless imposed a punishment that the 2022 statute said you couldn't impose. And the court, I think correctly, said, no, we're going to apply this retroactively because this is what the General Assembly is trying to achieve. That's far longer answer to your question that was necessary. But yes, there are studies out there, and one of the things the Commission fully expects to do is to compile those studies as we go through our other issues to make sure that the General Assembly and the people of Maryland are fully educated about the expert evidence out there.
Thank you very much, sir.
Thank you,
sir.
I believe Delegate Cardin was next.
Thank you, Madam Chair. Great to call you that. Thank you, Your Honor. It's always great to see you, and your passion and your energy is not only inspiring to all of us, but we think that it is helping make sure that our young people are in a better position because of the work that you and your commission do. So thank you very much. Just two quick questions. First, you spoke briefly about holding juveniles in adult facilities. And I just want to clarify that that is a different issue, maybe related, but a different issue than charging juveniles as adults. And those need to be dealt with in separate, particularly in Baltimore County, we have a very serious issue with holding juveniles in adult facilities. I just want to clarify that your commission is dealing with those separately. Is that correct?
We recognize those as separate issues, but closely related.
Yes.
Yes.
Okay, we want to work with you on that. Okay. Number two, you did just mention this briefly, but you talked about the reverse waiver hearing, and it seems as if what you're saying, and maybe as long as, make sure I understand, that essentially 8 out of 10 succeed in a reverse hearing. Is that basically what's happening, or is that, or maybe some of them are succeeding and some of them are the prosecution fails on the adult level? I guess it's maybe a combination of both?
It's a combination of both. And in our report, I could dig out the percentage for you, but yeah, most of those 8+ who don't end up with an adult conviction, most of them prevail on their waiver issue, and they're sent to juvenile court,
right,
where they should have been in the beginning.
So
and the others, you know, some get the charges dismissed for various reasons, but it's approaching 9 out of 10 who never get a conviction in adult court.
Right, which basically questions, if we're doing this and the numbers aren't panning out, then maybe we need to change how we're doing it, which is essentially what you're saying. But is the work that's being done on those reverse hearings, I know is costing a lot of money and is taking a lot of time, particularly from the Public Defender's Office, but not exclusively from the Public Defender's Office. Is that helping expedite the matter in the juvenile system because a lot of the work has been done, so therefore we can kind of move things along faster in the juvenile system because we have all that information already?
I get your point, Delegate Cardin, but net, no, it doesn't save anything. Okay. I don't want to get out of my lane. I'm not a public defender, but the truth of the matter is the harm done to the child while the child spends 8, 10, 12, 16 months in an adult facility, I don't think it's a net gain.
Fair enough. Perhaps that's something the Public Defender's Office that is listening could put in their testimony as on the bill, because that would be good information.
I'm sure they will be able to provide that. Senator Smith's bill, I think the number that we use and that Senator Smith's bill last year talked about something like $27 million would be recovered by a significant change in existing law, and those funds could be redirected to the Department of Juvenile Service. These are the costs of maintaining children in adult facilities.
Great.
Right? And so that's your net.
The money's there.
That's where the net would come.
So the final question, the idea is that there's judicial review on each of these cases, and there's a determination before it goes one direction or the other direction.
Yes. Has
the judiciary weighed in on whether they want this responsibility or not?
Well, they already have it, whether they've weighed in or not. They already have it. There's going to be a judge I'm sure there may be one or two cases. I shouldn't say one or two. Surely there are some cases for very good reasons in the judgment of counsel, in consultation with the child's family, guardian. I don't think a waiver motion is filed in every case, in 100%. So yes, there are likely to be some small number of cases where a waiver motion is not handled. But there's going to be a judge. And the question is, will it be the state's attorney, in our view, will it appropriately be, in vast numbers of cases, the state's attorney going to the judge to say, Judge, this offender, this person needs to be in adult court, as opposed to the public defender coming to the judge saying, Judge, this child can benefit from all the things that we know, traumatized children from dysfunctional families living in poverty. You just heard a description of a child who's growing up where food is a clinical issue for the child, not just in juvenile services custody, but living out here in the world, living here in Maryland, there is food insecurity. So again, we should trust judges. We should trust judges.
Thank you.
Thank you, Delegate.
Thank you. Delegate Phillips?
Thank you, Madam Chair. And thank you, Judge. You were very humble as you came up and introduced yourself as my law professor, as my friend, as a former circuit court judge in Baltimore City, and a federal district judge. I want to say thank you for taking this on. I apologize, Madam Chair, because I'm going to make some editorial comments.
Okay.
I am a member of the commission, and I really appreciate the way you have brought us together and guided this conversation and actually brought us to this issue being the issue. We've only taken one vote, and it was on this issue. And so one of the things I want you to do is to talk about kind of a little bit more about how we got there as a commission, and we took this on, and it was not unanimous. And so I think you mentioned some of the folks that won't be supportive of this. But I also want you to talk about what doesn't happen when a child is charged as an adult, placed in the adult system. What they don't receive during that period of time, that could be 1 month, 2 months. And in some instances, I think the chair, our chair mentioned yesterday one instance of a person, a young person who's been in the adult system for 400 days, right? So what is the thing that happens when you go through the juvenile justice system versus the adult system in terms of services provided, et cetera? And I'll stop there. But the idea that a judge is going to be involved anyway, I'm going to kind of make a comment. Baltimore County is one of those places, as my colleague mentioned, where we have a challenge, and we have these young people being placed in the adult system. But a judge is making that decision along with the state's attorney as to where that child is going to be housed. So the judge is going to be involved. I'll stop there.
Thank you, Delegate.
And I was one of your good students, right?
As far as how I'll be brief. As far as how the recommendation and the policy choice was made, each work group of the commission has two chairs, co-chairs, as I mentioned, and what we've done is we've taken the statute and we've sort of massaged the statute to try to create thematic or functional kinds of focus for each of the things that this General Assembly has told us we need to be looking at. So we came up with the 5 work groups. And so the systems coordination and procedures work group, under the leadership of its 2 chairs, decided to take a look at this question of compliance with the federal law and the causes for noncompliance and the overarching issue of children in adult facilities, which again is an issue that's been around for decades and really poignantly for the last decade. And so the work group prepared the report. As I say, it's really a synthesis more than anything new. It's a synthesis of data that's been collected over the years that points to really only one logical conclusion, that what we're doing is wrong and we need to do something else. And the something else is reduce the number of mandatory adult charging. Because when children are not mandatory, then they go into the juvenile system. And within 27 days, work is done to, answering the second part of your question, Delegate, what services does this child need in light of the behavior that is alleged to have been engaged in by this child, in light of this child's background, perhaps background with the department itself? In light of all of that, what services does the child need? Where does the child most appropriately need to live? I know that the issue ankle monitors and home detention, monitoring is controversial, always has been, I suppose. In a way, it always will be. But that is a legitimate law enforcement technique. A child who, with the proper supervision and the proper guidance, who is provided with the proper interventions and the proper services, can successfully live in the community and indeed at home with the proper electronic technology monitoring of that child's comings and goings. Okay? So that's one thing the child won't get, but more importantly, the child is almost certainly not going to get a full educational opportunity in an adult facility. I don't want to talk out of school, but in fact, talking about Baltimore County, I am aware a couple of years ago there was something of a serious interagency dispute in Baltimore County between the Department of Education and the Department of Corrections out in Baltimore County. Who's going to pay for the educational services? Okay? And you can talk about whether educational services are actually being provided in a sincere and effective way. But remember, a child is a child wherever the child is being held. So if you have a child with an individual education plan, an IEP, whether that child is in school in Howard County or Washington County or Baltimore City or Baltimore County, that child is entitled to that IEP implementation wherever they are. And it becomes as part of the cost. So a child has access to educational opportunity, mental health treatment, monitoring by the Department of Juvenile Services, placement in appropriate custodial settings, and reintegration into the community, which is going to happen for, let's be honest, 99.9% of the children anyway. Even a child who unfortunately gets a life sentence for something they committed, an offense they committed when they were 17 years old, thank God now that child will have an opportunity for reconsideration. So all these children are coming home if they survive their time in detention, which is not a given, especially for a young person in proximity to a more mature, a more experienced adult offender. So these are the truths on the ground, Delegate. Thank you for the question. And it does go back to Delegate Cardin's question. There is no net. There's no, I shouldn't say no, but I can't quantify any financial or other benefit in contrast to the almost certain damage being done to the individual child by keeping that individual child locked up in an adult facility for months on end, and then the child comes back to the community without those services, without those interventions, without that enhanced educational involvement. It's a compelling case. Thank you.
Thank you, Chair. Thank you for coming in to testify. So you spoke about prevention. Do you have any suggestions for prevention? Okay, well, I've put in the bill several times to teach the collateral consequences of a criminal conviction in middle school. It hasn't passed through both chambers, but maybe you might want to comment on something like that.
I'm sorry, I'm not familiar with the
collateral bill. It's a booklet, Collateral Consequences of a Criminal Conviction, put out by I think by the state of Maryland.
Oh, the collateral, there's a lot of scholarly research and social science research. Sure. The collateral consequences from a criminal conviction are just enormous.
But I'm saying, do you think that we should teach it as part of what you were talking about, prevention?
I'm sorry, I didn't.
You spoke about prevention.
Prevention.
And so as a preventive maneuver, do you think that should be taught to the juveniles, maybe in middle school or?
Oh, okay, I see. I'm sorry, I didn't understand. Apart from what is taught in a curriculum at a school, I'm going to stay in my lane. But part of the rehabilitative model, part of the restorative justice model that we want to immerse our juvenile justice system into is exactly that. Teaching young people, again, I'm trying to give my answers as short as possible, Madam Chair. I really am. I want to be respectful. But the incredible growth in knowledge in the last 20 years, the incredible work that's been done by neuroscientists and lawyers working with neuroscientists, what we know now about the child's brain has taken us to a whole new universe, a whole new galaxy about what the proper interventions for children are. And so when you introduce a restorative justice idea in the juvenile justice system, it will achieve exactly what you're suggesting. Children, the prefrontal cortex is not working for children. It's not. And so what we can do for children who are 13, 14, 15, 16, who do become justice system involved, by taking a restorative justice approach and having children talk about collateral consequences. And by the way, I don't think you meant this, Delegate, but there are collateral consequences and direct consequences to victims.
Yeah, I understand that, but you specifically said prevention.
Right,
this
prevention.
Is before you even get into the system, right?
Well, we can prevent a second offense.
No, I'm talking about to prevent the first offense.
Well, we're gonna work on that.
Oh, we're
gonna work on that. We're gonna work on that. And here's how I address that, Delegate. As we sit here right now, January 2026, there are fourth graders all over this state, hundreds of them, if not thousands. There are fourth graders in this state right now who are not reading at grade level. They're not reading at grade level. And I'm here to tell you, on the basis of my experience, my study, my work, my 30 years as a judge, my time as a prosecutor, those fourth graders 10 years from now, some of them regrettably, will be in the custody of the secretary back here. And we can prevent that. This state can prevent a large number of those current fourth graders who are going to be 13 and 14 years old a decade from now. We can improve their life choices, their life chances by what we do tomorrow and the next day and next month and next year. And of course, I'm talking about resources. I'm talking about services to families. I'm talking about educational resources. We can prevent juvenile delinquency. That's the name of the federal statute, folks. The Juvenile Delinquency Prevention Act. We can do it.
Okay, so if a juvenile is charged with murder, rape, or carjacking, do you think that they should be automatically sent to adult court or to juvenile?
So now, maybe I should take another seat. Because everything I've said up until now, I'm here on behalf of the commission. And I hope you will take everything I've said up until now as speaking on behalf of the commission. Now, you have asked me a question in my personal capacity. And when you and I have a coffee one day together, I'll be happy to tell you about my personal views about any and all of these issues.
Okay, well,
but I'm here as the chair of the commission.
Okay, well, I'm sorry. I apologize.
No. Honestly, I think it was a legitimate question.
But you did mention that some of the Maryland data is not included in the statistics that we received. Did you say that?
No, I did not say that.
The federal standards and the Maryland non-compliance?
Oh, no,
The statistics?
yes, the failure of Maryland to comply with the statute, those statistics
Yeah, you
are
said
not
Maryland-
included in the national data.
So therefore, the data can't be trusted, the national data can't be trusted.
No, I don't think I don't think that's true. I think people who pay attention to these things know full well that Maryland is an outlier. Maryland is an aberration. Maryland is way off the charts mistreating children through automatic adult charging.
All right, thank you very much.
Thank you.
Thank you. Delegate Mangione.
Thank you, Madam Chair. And just, he kind of stole a little bit of the question I wanted to ask. And on behalf, I guess, if you, the commission, the part about the more extreme, egregious, violent crime. But I guess my question now would kind of center around, is it true, the case that juvenile courts are more designed for rehabilitation, right? So not necessarily long-term kind of pre-trial detention for those type of serious offenses that the good delegate was talking about. So I guess, and maybe you'd have to speak over coffee too, not on behalf of the commission.
I'd love to.
But why not, again, keep these started for the most egregious crimes at the adult court?
I'm sorry, I missed the last part.
So, I mean, so the point kind of to the good delegate's question as well, the commission, did they consider, I mean, for these juvenile courts and it's more geared towards rehab and the offenses opposed to not being for pre-trial detention for some very serious offenses. So if you had a very violent charge for somebody and now they're being sent down, I guess you're trying to say the judge wouldn't use the waiver and just send it to the adult court? I want to make sure I'm understanding correctly.
Yeah, I'm sorry if I wasn't clear about this. The commission's recommendation does not mean, it's not intended to mean, and hopefully no one will interpret it to mean that there will not be children indicted, put on trial, and certainly some convicted either by guilty plea or by a jury verdict in adult court. That will continue to happen. I don't know if I'm addressing your question.
I guess my question and follow-up is just in terms of what kind of delay could that potentially cause? And obviously there's the question between public safety and obviously the betterment of the youth, right, and juveniles. But how much of a delay would it be if you decided for somebody that committed the most egregious crime to start off in the juvenile? I'm just asking your legal expertise because I'm not exactly sure how criminal court works in some cases. Could there be a delay in justice by starting it off, and just how much longer does it go on, opposed to somebody that is charged with the most egregious crime to just saying, start that person off in the adult court?
Okay. I hope that this answer I'm about to give you, Delegate, is...
Thank you.
And I really look forward to having coffee. I really mean it. I'm going to take you back about 35 years. I was a judge for 5 years, appointed by Governor Schaefer to the Circuit Court for Baltimore City. Courtroom 636 on the top of the Mitchell Courthouse. A unique courtroom where, in this courtroom, it's the only courtroom on the 6th floor. And in that courtroom, the defendant, the judge, the judge's staff, the jurors, lawyers, everybody came through the same door. So you came through this one door, and then my chambers was off to the left, the jury room was off to the right, and the courtroom was straight ahead. Okay? I hope my point lands. So I had a murder trial, homicide, murder one. I remember it like it was yesterday. A drug shootout. Ironically enough, a drug shootout 1 block from the East Side Courthouse in Baltimore City, North Avenue and Harford Road. And some judge had put a $100,000 bond on the defendant. Guess what? He posted the bond. So for that entire trial, the defendant charged with first-degree murder, and frankly had a little entourage with him every day. He was free to come and go in that trial, and some days he would be walking in alongside the jurors because there was only one door into that courtroom. I shared that with you, and I hope it's responsive. This idea, with all respect, that the purpose of pretrial proceedings is to make sure that somebody who is charged with a serious crime doesn't get released is, with all respect, not only misguided and wrong, but in fact, in my humble opinion, and I'm trying to be humble here, it's unconstitutional. It is actually unconstitutional because the presumption of innocence applies whether you're a child or an adult. And the idea that the purpose of setting a bail, rather than to ensure the person shows up, right? When you set bail, you're supposed, first of all, largely we've gotten rid of money bail, and that's very controversial. I understand that. But the purpose of bail, the purpose of pretrial conditions of release in the criminal context is, one, public safety, and two, to make sure that the person shows up when they're supposed to. Those are the two purposes. The purpose of setting bail is not to set a bail so high that you have reasonable confidence that this person won't be released. So I don't know any other way, if I've understood your question, to answer your question. The harm that is done to the child sitting in an adult detention facility is incalculable in most instances. And there are techniques, technology, monitoring, and others that can ensure public safety. I left that slide up there on purpose because there is no, I'm speaking for the commission, there is no space, in my judgment, on the part of the commission, there is no light between the commission's commitment to public safety and the commission's commitment to do right by children. We can do both. We must do both. And we can talk further over coffee, but this idea that by keeping a child charged with a serious criminal offense in pursuit of public safety needs to be rethought. I'll put it that way.
Thank you for answering.
Thank you.
The good delegate took my initial question, so I might have been some confusion as I thought on the fly there, but I appreciate your answer.
Well, thank you. You gave me a chance to tell that story. Some people in here probably heard it before. By the way, he was acquitted. He was acquitted.
Judge Davis, we're going to have to wrap up. We have one more, Delegate Simpson, and please put on your coffee list our juvenile subcommittee chair, Delegate Woods, please.
Absolutely.
Go ahead, Delegate Simpson.
Yeah, and I might come along just because I think to me, there's always this intersection and didn't know how to put it into the bill or put it into the commission. You know, my background is child welfare. So how much interaction you had with child protective services as opposed to juvenile services. And then I went and married a juvenile services guy. So to me, a child who is doing these horrendous, behaviors, burning things, or they are killing things, or they are other things, are usually just screaming something happened to them. They just don't wake up one day and start doing these behaviors. And we really seem to lack, in Maryland, I've never understood why we just have these two paths. It's like you're either holding the child accountable and you're not really doing that thorough investigation that would properly be the Department of Human Services. You know, you have the behavior, it is clearly saying something is happening. And I know the law says there is, that they look at, but I also know it's woefully, it's not as thorough as the Department of Social Services to do an actual investigation as to whether or not neglect or abuse, or most of these behaviors are actually red flags for sexual assault. Where do you see that intersection of juvenile services and family services in these types of cases, so that we can stop, if you're talking about, you know, protection, if you're talking about prevention, if we're talking about public safety, how are we looking at the community? How are we looking at the family? How are we looking at really not just, I know we talk a lot about school, but it's more basic than that. It's when they wake up in the morning or go, unfortunately, maybe go to bed at night. Where do you see that intersection? Have you ever seen in your travels and education where somebody's done it right, where they're looking at both?
Great points, Delegate. Thank you so much for sharing that. I can tell you, my short answer to your question is they are inextricably intertwined, inextricably. Again, going back to my time on the Circuit Court for Baltimore City, people used to say to me, the hardest thing a judge does is what? Sentencing someone to prison? And I would always say, no, that's hard. Sometimes it's pretty easy, frankly, because you have a recidivating, you know, defendant who has done what was proven beyond a reasonable doubt, or that they admitted to, that you know in your heart of hearts as a judge, this person has got to age out of his criminality in prison. So you impose a long sentence. But the hardest thing, in my opinion, my humble opinion, a judge does is termination of parental rights. That's the hardest thing. Because as you alluded to in your comments, and I did a number of those cases, and you've got this family in front of you. I had one once with 5 children, and the Department of Social Services had done everything it could possibly do to keep this family together. And of course, as happens in many of those cases, at the end of the day, I'm the judge, I gotta make this decision, and of course, not to denigrate the efforts of the parents, but they got sober for a while, they, you know, they really wanted to keep their family together. And so it's on the judge to say, no, we have reached the end of the line for these children. I have to terminate your parental rights with this child in order to give this child a genuine chance. So absolutely, you know, the Department of Juvenile Services should probably be renamed the Department of Juvenile and Family Services or something like that, because you can't work with the child in isolation. It's impossible. Well, I shouldn't say it's impossible, but yeah, it takes a village is what it takes. And a big part of that village are the family, whatever may be left of it in a very traumatized situation. It takes family, community, and more than just a single agency, and certainly more than just our commission, to holistically address the concerns that you rightly identified.
Right, because I do think that what we currently do, if the why is that the child has been harmed by someone, and we are not giving the family the resources to protect that child, then they are only going to be re-traumatized. Some of the same things, and it's impossible, I think, in your role as a judge to say, I care about you from that bench, you know, to a child that is ending up going into a worse situation than perhaps what they came out of. Yeah. You know, how does that say that you care, or anybody has even asked, well, what happened? Why are you burning things? Why are you hurting others?
Yeah. A big part of prevention does involve working with families. And within the commission, we've got to figure out frankly, how we can fold some of that work into our more precise work of working with the department and making recommendations for the juvenile system.
Turn the mic on, Deborah. Thank you so much, Judge Davis. I think everyone has asked their questions. You have several coffee dates scheduled. Thank you so much. You've been very thorough, and we appreciate all of your work.
Thank you. And I want to apologize to the Secretary, but they had me listed last. So I want to apologize to those who come after me.
All right, thank you so much. Secretary Tolentino is next. Thank you for your patience.
Thank you for having me, Madam Chair.
Sure.
Members of the committee, and I'm Betsy Fox Tolentino, the Acting Secretary at the Department of Juvenile Services. And as they pop up these slides, I'll get started with a few things that we can touch base on before we get those slides up. But I want to say something Judge Davis mentioned is it takes a village. And I can't agree more. And I want to recognize our village in the room of the Commission on Juvenile Justice and Best Practices, helping us chart a course forward, keeping ourselves in line with what we know works and where we should go to get the outcomes we all want to see for our young people. Our Office of Correctional Ombudsman, who's doing a very important job monitoring our facilities, checking in on our young people, and advocating for change. We partner with all of them, and we appreciate their comments today. So with that, here we are, been on the job for 6 months. And I still love it. And this is the job I've always wanted. And to do this work is such a privilege, and I'm incredibly grateful to Governor Moore calling me up and asking me to take the lead, especially at this critical time. And I want to say, really just introduce myself really quickly. For the past 20 years, I've worked in and around Maryland's juvenile justice system. I started out my career as an attorney at Legal Aid in Baltimore City. I went on to the Office of the Public Defender, where I represented clients in Harford County and in Baltimore City in juvenile and adult courts. I did the legislative work for the OPD. I was here many, many times advocating on behalf of the Office of the Public Defender. And then I went to go do that at the Department of Juvenile Services. And I worked at DJS for 13 years. I left as Deputy Secretary for Community Operations. And then I went to go work for the Roca Impact Institute for the past 3 years, having the opportunity to work in residential facilities, probation agencies, and community-based organizations around the country, bringing strategies to disrupt violence in communities and empower our frontline staff to do the work differently to inspire change in our young people. So with that, I want to say, if it weren't for the frontline staff who show up every day at our agency, we would not be where we are. They are coming in, doing hard work, showing up for our young people, and it has been a priority of mine to make sure we are equipping our staff with what they need to continue to be successful. So a few guiding principles as I moved into this role a few months ago. One is investing in that frontline staff, creating more opportunities for youth accountability that are developmentally appropriate, making sure our community-based responses are presented with clear expectations for our young people. We have work to do in our residential facilities. I will touch base more on some of the stuff the Ombudsman's office brought up as we go through this presentation, and we'll add in a few things that in response to some of the questions from the committee, but also really establishing an effective oversight structure that is based in data and focused on tracking outcomes. And when I started, it was very apparent that we needed to rebuild relationships with our stakeholders and re-engage those who also do this important work every day. And to that end, we reached out to law enforcement. Just the other day, I talked to both the commissioner from Baltimore City and the chief from Baltimore County. I've had constant conversations with the Maryland Chiefs and Sheriffs Association and opening up that important line of communication so that we can understand how they are experiencing our system and how we can be responsive to their needs. I've worked with our State's Attorneys Association Again, going out to localities, talking with state's attorneys, attending their conference and their association meetings. I'm working with our Office of Public Defender and hearing from them, as well as the courts. And a lot of that listening is happening in localities. I'm reaching out to their statewide meetings, but I've also spent an incredible time on the road the past 6 months, going to community and hearing directly from community as to what they need. And also I want to mention our union leadership team. You know, we also had to re-engage at a leadership level with our union representatives, and that means me going to our LMC meetings, me sitting there, hearing the concerns and coming up with shared solutions. And then our youth and families. I'm in facilities, I'm in our programs, I'm in community, hearing from our young people and hearing from our families as how we can support them. Because we all have a common goal at the end. We want to support our young people. We want them to achieve their goals. We want to put them on the right pathway, and they are the ones who have the best information on how we can do that. And expanding our options for community, everywhere I go, every community I talk to, I heard we need more programs, we need more services. And over the past year, we've invested $30 million into new programming around the state with $10 million in just new initiatives. We've brought evidence-based programming back to Baltimore City for the first time in a decade. And we created Safer, Stronger Together a few years ago, which is a powerful partnership between the Department of Human Services and the Department of Public Safety and Correctional Services to work with families who are touching 2 or more of those systems. We are targeting zip codes in Washington County, Wycomico County, and Baltimore City, and Prince George's County, and we hope to continue this innovative partnership where we are engaging community. Community advisory boards are making the decision on what services they need. They are picking the providers. They are holding those providers accountable to doing the work, and we're providing families with family navigators to make sure they are getting what they need to disrupt the cycle of violence and make sure they are on the right pathway. We are also completing a gap analysis. As we expand our continuum, we want to make sure we are making these decisions in an equitable way, which means we are looking at all our services, we are looking at all our young people's needs, we are talking to community, and we are in the final stages of having an analysis done by our researchers to say, here's where you have gaps, and here's how you need to fill them so that we can be strategic, equitable, and focused on how we make our next decisions of how we deploy resources. One initiative in particular I want to mention is our Thrive initiative, is our framework and program towards disrupting gun violence in community. We have served 218 young people over really the past 2 years, and we are looking at serving the riskiest young people, those at most risk of being a victim or a perpetrator of gun violence. And our early indicators are really promising. We've had 0 of those young people be a victim of homicide, and 83% who have not had any new arrest for gun possession. One other thing I heard everywhere I went, whether I turned on the radio, the news, or talking to community, is electronic monitoring and community detention. And so we dug into that really immediately upon my entry and return to the agency. And what we saw is most people, most young people on electronic monitoring do just fine. About 83% complete the program with no new arrests, and they show up for court. But that leaves a percentage of kids who are falling through the cracks. So we knew we had to do something different. So if a young person, we changed the policy, if a young person is rearrested while on the electronic monitor, they will be detained until they go to court the next day. We will ensure the community detention officer is in court to make sure the court has the best information as well as the other stakeholders in that proceeding. But I just didn't want to focus on a carceral approach. We provided more training to our community detention officers and coaching so they are equipped to build skills with young people to disrupt violations before they happen. And I'm trying to talk fast because I know it's been a long day. So if I'm going too fast, I will try to slow down. And as we heard from the Ombudsman's office, our residential facilities were in need of attention. They were in need of reinvestment and reimagination on how we're going to serve our young people and equip our frontline staff. And we started with really stabilizing our staffing. And when I got there, it was like, first day on the job, I go out to Western Maryland Children's Center. I get there, it's 11 o'clock in the morning, kids are still in their cells. Like, why? Oh, we don't have enough staff to take them out. 100% unacceptable. So I was like, what is going on here? We dug deep, we realigned all our resources, we looked at every single one of our vacancies, and over the past 2.5 years, we noticed about 50 positions were removed from the residential facilities. We were able to return those positions back to the residential facilities, and along with some other strategies, have really relieved some of the staffing pressure. Now, we're not there yet, but we're making progress in the right way. We rebuilt our residential leadership team, not just at the headquarters level, but now we have a superintendent in every single one of our residential facilities, which we did not when I started. Now we do. And we really focused on reducing that use of overtime. You know, overtime, this whole staffing thing is like lighting a match on a vicious cycle, right? If I don't have enough staff coming in, then the kids aren't getting what they need. I have more incidents, more staff get hurt, then I need to draft people, and I'm using more overtime. Now I have less staff, and no one is getting what they need. And so we also focused on reducing overtime by putting in, basically statting our use of overtime every week. We put in several strategies, automated the process, created an approval sort of framework so that we know who's using overtime, why they're using it, and also use some of the other tools just to make sure we were staffing things the best we could. Over the past 6 months, we've reduced the use of overtime by 15%, the greatest reduction we've seen in the recent history that we can look back and see our utilization. We also have put a lot of effort in safety and security. And what that looks like for us is a partnership, again, with our Maryland State Police and our Department of Public Safety and Correctional Service to use canine searches. Now, we do not search our young people with canines. When the young people are not in their units, we bring the canines in to make sure that we are detecting contraband that is not supposed to be there. We have done additional training for our staff who are doing our searches. We have added in monitoring of visitation. And I want to be clear, that's monitoring, remote monitoring. We do not want to frustrate the visitation process by having staff over top our young people and their families. We can use technology to do remote monitoring to make sure we're not seeing a handoff of contraband and that our staff are actually searching and doing the things they're supposed to do to keep everyone safe. We are putting a dedicated staff person in every facility that their job will be to oversee safety and security and continue coaching. We just can't do a training one day. We need the continued coaching, support, and skill building to create a safe facility. We have expanded our oversight process to make sure we're moving towards our standards. We've added additional programming, dedicated new staff who their sole job is to curate and implement programming in our facilities. We are changing up our treatment model. I'll talk a little bit more about that in a second. But what also I think the Ombudsman's office was really clear about, we do have an aging infrastructure. We have old facilities. It's like constantly throwing a Band-Aid on a problem. We have a dedicated facility team that is working so hard to keep those facilities safe and secure. We have expanded contracts that have additional deep cleaning. And we just did get a new vendor for our pest control who started on the 14th, specifically at BCJJC, increased the frequency from monthly to biweekly. He already was there just a few days ago, and he thinks like he found like the entry point of where we're seeing some of the pests come in. And we've also put door sweeps under the doors just to have another mitigation strategy. There's additional traps all around the building at this time. But I started my career in that building, and it's been an ongoing problem for 20 years. I'm hoping that with our renewed effort, we're going to be able to disrupt that problem. And I just wanted to touch base a little bit more on investing in frontline staff, because it is about getting more staff. It is about reducing overtime, but it's also giving our staff the opportunity to build new skills along with that coaching and support, so we start to see culture change sort of take place in our facilities, and we're getting there. And just the other day, the Juvenile Protection Division of the Office of the Public Defender went out to Hickey, interviewed 20 young people, and reported back to us that those young people feel cared for and that they're getting getting what they need. We're not perfect. We still have work to do. There are a lot of problems we have to solve, but these are encouraging indicators that we're going in the right direction. All right, operational improvements. We got a new inspector general. The monitors team mentioned that they meet with her monthly. She's fantastic and hitting the ground running on renewing our auditing and our incident and search procedures. We've launched bi-weekly cross-departmental workforce meetings. We have our weekly data-driven performance reviews looking at data each week so we know, hey, something's popping up here that doesn't look right. So we can adjust immediately instead of waiting for some quarterly review. We are in it every week. And we launched a public-facing dashboard. So those of you who've seen our data resource guide, that really thick book with all the data, all the numbers, it has everything in there, but it's not the most easy to navigate. So now we have a public-facing dashboard that has a lot of information right at your fingertips. You can look for your localities and access who's coming in the system, what are the offenses, what is the recidivism. And so we're really looking forward, as this is our version 1 of the tool, and as we continue to expand how we can have more accessible data for all of you to utilize. So speaking of data, let's go run through some real quick. And I'm just gonna sort of point out some highlights on each of these data slides. This first slide are the complaints that come in the front door. This is really a proxy for arrest. Over 90% of our complaints come from law enforcement. Community members, family, other agencies can file complaints, but generally over 90% are coming from law enforcement. And you can see over the past 10 years, we've had a decline in the number of complaints overall coming into the department. But I want to focus on the past year, where from fiscal year 24 to 25, we saw a 6.4 reduction in the total number of complaints, with reductions in all categories: nonviolent felonies, crimes of violence, and misdemeanor offenses. But we also wanted to look a little bit closer in time. So comparing the first 6 months of this fiscal year to the first 6 months of last fiscal year, we're seeing an 8% decline in the total number of complaints, a 3.5% decline in the nonviolent felonies, a 9.5% decline in misdemeanors, and a 20% decline in the crimes of violence coming in the front door. Again, we have not won the day yet. We want to continue to drive these numbers down, but again, these are some early indicators that our strategies are working and we are again going in the right direction. I just want to point out a few just specific indicators. One is in 2025, we saw homicides statewide of juveniles drop 37% and 67% in the city of Baltimore. And we've also seen motor vehicle thefts drop by 22%. So now we gotta look, okay, so we know what's coming in the front door. Now you gotta look at what we do with those complaints that come in the front door. So DJS makes a decision on whether to forward cases to the prosecutor, divert the complaint, or resolve it or effectively close it. DJS has to forward almost all our complaints to the state's attorney. We have to file all felonies to the state's attorney, all misdemeanor handgun violations, and all complaints where a young person is already on supervision. So that would be a misdemeanor if the young person was already on probation. Those go directly to the state's attorney's office. So basically for the misdemeanors, without priors or not currently under supervision and non-handguns, we have some wiggle room to use diversion. And that's an area we need to improve. And that's because that's the little purple box that goes along the middle here in this slide. We want to see that box grow and use diversion where appropriate and reduce the number of cases that we're resolving. All right, so now we got to cases. We know what's coming in. We know the decisions DJS is making. So let's see what happens when the cases go to court. So when we get to court in fiscal year 2025, about 40% of the cases that go to court are dismissed, disposed of, might not be guilty, but are basically they don't move forward. About 30% of the cases that go to court are put on probation, and 10% of the cases that go to court end up in the young person going to residential treatment programs. What I want to focus here, this is our detention utilization. What you see is a lot of what Judge Davis was talking about, where youth charges adults, and that's the big green box on the bottom. In fiscal year 2025, 60% of my population on any given day is a youth charged as adult. They stay longer, as I think I might have given, I think it makes sense, but okay. But Judge Davis mentioned is that they stay a long time. So on average, a youth charged as adult is sitting in detention for 124 days, just waiting for that transfer hearing. The range is 1 to 800 days. Compare that to a juvenile charged in the juvenile system, their average length of stay in detention is 20 days. All right, so now we're going to out-of-home treatment. These are my residential treatment facilities. These are the committed facilities. That's Green Ridge and Backbone out west, and Victor Collin in Frederick County. We also contract with some private programs. What I want to point out on this slide is see that, good size orange box on top in 2016. That's our out-of-state population. You can see that we have compressed the number of kids who need to go out of state to receive services. But again, just as in detention, half of the population in my residential treatment centers started out in the adult court. I'm going to touch on recidivism really quickly. This is our 12-month recidivism reconviction rate. We look at juvenile and adult records to see if a young person recidivated, and we're looking at convictions here. In 2023, youth who are charged in the juvenile system and put on probation, 80% of them had no new convictions within a year. And our youth charged as adults who came back to the juvenile system, 82% who were put on probation had no new convictions in 12 months. We want to look at that as well for those kids who go to our residential treatment programs. In 2023, 81% had no new sustained juvenile or adult convictions. For those are the young people who were charged and proceeded with in the juvenile court. Those who started in the adult court and came back, 87.3% had no new convictions in the juvenile or adult systems. All right, what's next? We have a lot of things that we are trying to tackle and move forward, and I look forward when I get to come back to you and give a status update on where we are. We are updating our objective tools to make sure that we are using them in a way to help us make the best decisions for public safety. We'll have new tools being released for detention in the middle of February, and for our intake decision-making probably towards the end of March. We're revamping our residential treatment program. Right now, the treatment program's just based on dosage, like how much treatment we're getting a young person, which is part of it, but we need to know if that treatment is actually getting us to the behavior change we want to see. So we're going to look at dosage plus sustained behavior change over time. We are expanding workforce partnerships. Our young people are much older than they were when I was here 3 years ago, and we need to make sure we're giving them the tools to be able to be on a pathway to independence when they return home. We are focusing on our reentry programs, not just on our deepest end young people who are going to our residential treatment programs, but those who touch detention. Nearly 50% of the kids that we detain leave detention without being on probation or going to treatment programs, which means they're done. Their cases were disposed of. And we don't have any supervision, so they go home. We need to support them because 60% of those young people come back. And so we need to look at how we're doing this differently. I'm so excited. We have a new superintendent in the Juvenile Services Education Program who is focused on, with this population, making sure they're getting back in school and dedicating staff to do that. Our next step is to leverage SST, that Safer, Stronger Together partnership where we have it, and then expand into family navigators for young people who are leaving detention without those supports. Look, I am not where I need to be in our hiring process. So just as I statted that overtime utilization, we just started statting our hiring process. Each week, we're getting together, seeing where we can build efficiencies, put new strategies in place, because we have got to be able to hire people faster to fill our vacancies. And lastly, new coaching, new training, and new supports for our frontline staff. And that doesn't mean just here's your 6-hour training. It means how do we have the ongoing coaching to support you each day? And with that, I'm done. Thank you.
Well, I think Madam Secretary, I thank you very much for being here. I didn't get a chance to welcome you to our committee. And Judge Davis, I'm sorry that I wasn't here, but it's all, I can look at it later and I will review later on. I was giving members a chance to light up, and I am now seeing that, because I know members had questions. I think you just, everybody was surprised at the quick ending, the way you ended, but it's all fine.
It was abrupt.
It's all fine. Okay, I saw Delegate Conaway first, and then Taylor, and then I'll come on over to the side.
Thank you, Chair. Thank you for coming in for the presentation. In reference to the building relationships slide, the first entry was law enforcement. And I was wondering, do you have any comment on there being a bill about law enforcement using false statements to juveniles while interrogating them?
I mean, I'll take a look at I have not seen that
You haven't seen the
legislation, Delegate.
Okay.
But what I can say is that we are really collaborating and moving those relationships forward, and so I'm really pleased
Well,
with.
that's very
yeah.
specific, so that's a very specific question. My second question is, in reference to the 8 out of 10 juveniles that get charged, and then you say about 60% come back, does that mean about 5 out of 10 recidivate?
So I think a few different stats there, so just want to clarify. Judge Davis mentioned the 8 out of 10, those who are charged as adult who come back to the juvenile system. I agree with how he shared that data, and that's actually true. We serve most of the youth charged as adults already, and making improvements will only allow us to do it better. Now, the kids that I was talking about, that detention population, is including both those charged as adults and those charged as juveniles. About 50% of them that touch my facilities, my detention facilities, will leave without supervision or treatment. We want to make sure we're providing something to them because they come back to our facilities at a very high rate.
Okay, did you want to make any comment on what we could do for prevention before a juvenile has contact with the system?
Yeah, and that is an area the department honestly needs to improve on. We need to do better, especially as we can utilize our SINs, our child in need of supervision process, for when we're seeing those behaviors that really worry us and are probably tied to their basic needs not being met. And we can intervene differently. We've hired just recently a new staff person who's going to help us reimagine our front door of the system. And we look forward to making changes and sharing those with you as we implement them.
Thank you very much.
Thank you, Delegate Conaway. Delegate Taylor.
Thank you, Madam Chair, and thank you, Madam Secretary, for being here, Acting Secretary. You know, I've got like 6 questions. I'm trying to combine them so I don't take up a lot of time. But I serve on the Home Detention Monitoring Work Group. And you did say that there are certain violations that when they occur, then you have to detain. Just wondering, what is an example or what kind of violations happen that would cause you to have to detain?
So really, we're going to use detention when all else has failed, right? So often we will see a young person returning to detention, one, if they're rearrested. While on the ankle monitor, we will use detention. We've had to activate that policy 22 times in the past 6 months. We also will see detention utilized when we lose contact with the young person. So either they cut the bracelet, they go AWOL, we're unable to locate them, we've tried everything, then we will ask the court for a warrant, and then they will be brought into detention.
So they're more egregious violations, not
Yes.
just that for 10 minutes I was outside of my boundary or anything like that, right?
No, and we have to report every violation to the court, and we do that. So it's almost like a second look. If they see a violation that's super concerning, any one of the parties can always ask for a hearing.
Okay, all right, I guess I got that, but, and then I think this is all a part of one question. You mentioned that PINs or, a staff were restored at residential facilities. So I guess this is all kind of the same. So when did that happen? And I guess a part of that also is, you said we're staffing up faster. What stops you from staffing up faster? And, the commission has had recommendations, the ombudsman have recommendations. So what are the what's the biggest hurdle then that stops you from doing it faster?
You know, as we are digging into it, you know, part of it is there's administrative processes that this is the way we've always done it. You know, we also have antiquated policies where our practices, so for example, all applicants have to get a psychological examination. And so our clinicians who are supposed to be serving our young people, they pick that up and they go do the psychological for all the applicants, and they go out to them or they meet somewhere, and it takes a lot of time. In partnership and leaning into our sister agency over at Public Safety, we're like, what do you all do? And they have technology that helps them do that. And so we are looking at procuring the same technology to be able to do those psychologicals through an app and then have remote contact when those psychologicals do not yield the results, or if it's essentially a fail, then we can go back, we'll have a psychologist reach out. So building those types of efficiencies. We also learned from the Department of Social Services in Baltimore City how they have a one-stop shop. You know, we are sending people out to go get drug tested. We can certify our own staff and just do it there, right? We can take some of these delays away. And so we are in the process of putting some of this in place. But like I said, I'm meeting with my HR team every week to look at where we are, how we're getting people moved through, and we're already seeing the benefit of that. And then I hope that we get even better as we build in some of those additional strategies.
Very good, Delegate Taylor. You had 6 questions. You said you had 6, but you concised it. All right. Delegate Simmons and then Delegate Phillips.
Thank you, Madam Chair. And thank you all for being here today. It's been very insightful to hear the testimony across the board, a spectrum of what we're doing to serve our young people. A couple of questions. Number one, you talked a little bit about the SINs petitions. Last year, we spent a lot of time around this, and I think for a lot of people, it was an educational form of looking at how we're working with school systems and the criminal justice system to make sure that we are providing the adequate services for our young people. Can you tell me either currently or moving forward, what are y'all doing to make sure that y'all are working with our on-the-ground law, the patrol officers or the schools in a sense of making sure that we have a wraparound program to support the initiative behind making sure we're providing a pathway for these young people as they enter the criminal justice system, or to prevent them for as demonstration. I'll tell you, I visited the Baltimore location, so we want to be able to help grow these programs. Can you tell me some best examples?
Yes, and I agree with you. I think the challenge with SINs when the law changed about 4 years ago was the implementation and communication around how we can use SINs as an effective prevention measure. And the agency has done it before. Years ago, you know, before some budget cuts, maybe 10 years ago, we had the SINs pilot program, and it was very effective. We're trying to bring that thinking back, and so we are going to have our new staff person help us reimagine how we're using SINs, but I've already had several conversations with law enforcement reiterating we've created some tools so it's clear when you can use a SINs petition, what to expect when you see a SINs petition, and also when I presented at the Judiciary's Can Do conference, I suggested that we put together a work group between the Judiciary, the State's Attorney, Office of the Public Defender, others, stakeholders, to really see how we can continually improve this process, because it does involve a lot of other stakeholders. And I think collectively we can come up with some really good solutions.
Absolutely, and I think that's important. That's what's needed. I go out and I do ride-alongs with law enforcement agencies around the state, and everybody, when I ask them what is the biggest issue that they're facing, everybody says juveniles, right? So that becomes weaponized, right? So that's, I think, what some of the advocates are talking about here, that the system actually is weaponizing how we are perceiving our children, you know, with that pre-notion that they're guilty, you know, and that they deserve that punishment. One of the things I did notice too and when I went to visit that facility, there was a large number of kids due to their age of being detained that had not achieved their GED, right? So can you talk a little bit about that initiative?
Yes, so our new superintendent of our juvenile services education program is very focused on making sure we have multiple pathways to get our young people what they need. And when it's appropriate, we want to use the GED program. We have a pilot program. So getting a GED, it's sort of tough. It's a high school diploma, but it's tough here in Maryland because we have compulsory education. You got to go to school till you're 18. There's waivers for that, and we have worked with MSDE to create a waiver process for our young people who are in our schools. We have a pilot program in several of our schools. We are looking at expanding that and also meeting with the Department of Labor, I think this week or next, on how we can even make sure we are doing this more effectively and creating more opportunities, even more opportunities as we can, then you get the GED, let's go now do something else and try to get you some workforce development programming.
Absolutely. Thank you. And that workforce development program is critical when it comes to teaching them skill set for when they exit.
Absolutely.
Thank you, ma'am.
Delegate Phillips, I'm going to go to delegates to next, just to keep it order. Thanks.
Thank you, Madam Chair. Thank you, Secretary. I know it's been challenging as far as coming in, and especially, I mean, you've done a lot of progress as far as within 6 months. My question, just to kind of get some clarity or just some understanding that, you know, I'm really focused on just the overall health of these youth, especially in these facilities. I know that a lot of these state buildings, they have issues all around. It's just not with any DGS facilities. They're old. But, and I heard you talk about as far as on the pest control portion, but outside of that, I know that's probably one of the many problems as far as dealing with these buildings. What else are you doing in terms of just facility maintenance through these buildings to make sure that, you know, these issues are being taken care of, as well as I know that, of course, within 6 months, I mean, that's not enough time because it's a lot to be done. But what are you doing in terms of facility maintenance with these buildings?
So we're really modernizing how we approach our facility maintenance. So over the next several months, we're putting QR codes on all the things in the facilities. So we can monitor, hey, yes, our facility maintenance person went and checked this area, they checked this thing, we have it documented, and if there is a concern or need for maintenance, then we can put it into our automated system to make sure that maintenance is getting completed. We have a great facility maintenance team, and because of our aging facilities, we've built up the ability to do a lot of the work in-house, but we still need to give them more tools, and we need to create a system of oversight, and so we're putting that in place. And it also will, it sort of also goes along, I failed to mention, our system that we will be putting in place to monitor our supplies and food that come in. So we'll have an electronic system to be able to see, hey, the tomato sauce came in, here's the expiration date, it gets scanned, and over the next several months, I think we'll probably need about 3 to 4 more months to get that in place. But we're putting in these things that we can say, hey, we are checking everything. We are going to have to do projects. We're going to have to come and ask for support and funding to do that sometimes, but we are going to be on top of it.
Delegate Phillips.
Thank you, Madam Chair. And Ms. Secretary, thank you very much for coming in and sharing with us today. And I want to thank you for coming to the 10th District to do our town hall. I really appreciate that and helping to educate people, because this is a lot of mystery in what happens in DJS until people actually get to hear from the experts. Having said that, I want to touch on a couple of things, and I'll try to, Madam Chair, put them all together so they can answer. For youth pending transfers and housed in DGS facilities, what plans does DJS have to come into compliance with the Sight and Sound Law? Also, when thinking about that, with all of the fact that we've been fined and we're actually kind of losing money in this process, what have you begun to do to try to address that to get us back in compliance? Talk to us about a wait list of placements. And then the last piece of all of this, our girls in particular in the system, we really have no place to place them. If you could talk about those three things. I think they're all related.
All right, I wrote them down. Okay, so the youth charged as adults, most of them are in my juvenile detention facilities. That was a law that was passed maybe 12 years ago, that there's a presumption if you are charged as an adult, you are going to wait in a juvenile facility pending that transfer hearing, with the big exception, unless there is not enough space. And there are times where I do not have enough space, and that puts pressure on our adult systems, our adult facilities around the state. And so my job in this is making sure that we are leveraging and managing our population so that we can create space. Right now, I think there's about 12 young people in adult facilities around the state who are waiting to come to my facility. We created a public website so you can see, judges can see, other stakeholders can see at any time if there's a wait list or not to get into a particular facility. But I think leading into what we heard from Judge Davis is there are changes that can be done to help efficiently move young people through our systems so that we are not relying on utilizing those adult facilities, and that young people are where, this body years ago said they should be, which is in juvenile facilities if they need to be detained due to public safety. Wait lists for placements, we do have what we call pending placement. Young person goes to detention, they go to court, court says you're going to a treatment program, then we do assessments, and sometimes we have to wait for a bed to become available due to the young person's particular needs. And so, for example, if they need to go to a residential treatment center for really acute behavioral health needs, sometimes there is a wait to get into those placements. Again, that's managing our population, managing not just who's in detention, but who's in those committed placements. We've created monthly and weekly reviews depending on the facility on making sure we are moving those young people as best as we can. We've seen those waits come down, but again, we're not where we want to be. We still have to build some efficiencies into the system. And lastly, with girls, we have a request for proposals, a procurement out there on the street to start up a new girls staff secure program. We do not have one in the state of Maryland for our young people. So when we think of residential treatment centers, we sort of think about it in 3 security levels. One is community-based, meaning it's like a group home, kids go to school in the community. Staff secure, it's a little bit more secure, sometimes in on-campus schools, sometimes they go to community schools, and then hardware secure, where movement is very much restricted by locked doors and fences. We do not have staff secure. Hopefully, as this procurement wraps up, we will be able to open a staff secure placement here in Maryland, and we're looking at our current sort of continuum of physical plant and facilities to see how we can best serve those girls who are in hardware secure programs. Our girls population, we may have 10 one day and 2 the next. It's very dynamic, and so it makes it hard to sort of build that economy of scale, to build out a really strong continuum, but we are dedicated to making sure all our girls have access to a full continuum. Just because they're a smaller part of the population doesn't mean they should have less access.
If you don't mind, on the sight and sound issue, there's a little unique twist to that, right? So if I have an 18-year-old that's in our DJS system that's in there with younger individuals, how are we dealing with that?
So we can keep those kids are okay. So I can serve young people up to the age of 21. So as long as they're under 21, that sight and sound separation doesn't apply within my own facilities. Okay. That applies in the adult facilities where we know we don't want adults to be able to hear or see, or young people to hear or see adults.
Okay, I didn't understand that. So thank you. Thank you for that clarity. And then one last question, just about you're talking about having more pens and bringing more people in. What are the qualifications that you have to have, particularly for persons that do intake? And what are you looking for from a qualifications perspective? Is there a standard?
So we have COMAR standards that direct our hiring requirements. So for an intake worker, they're considered a case manager, and so they need to have a college degree. And so that's sort of the baseline. We look for juvenile justice experience even being able to make decisions in the juvenile justice setting. But we are putting a lot more oversight and tools in place at our intake, at our front door, because that's where we get to make the most change, right? And we want to be able to leverage as much as we can to make sure we have the appropriate off-ramps and on-ramps that are aligned with public safety and what our young people need.
Thank you.
Okay, I'm going to go back around again. I'm going to go to Delegate Embry, and then I'm going to go around this way and get back to, okay? Delegate Embry.
Thank you, Madam Chair. And thank you, Madam Secretary. It's just been a pleasure. I've known Madam Secretary for many years and just so happy to hear everything you're saying and many things that we've been concerned about. So just bravo. I want to touch on one thing you said, which was better evaluating the residential treatment programs and not just checking boxes and not just saying, well, they did the program, but looking at rehabilitation, which is the whole purpose of the system. And I know because of the work you've done at ROCA and all your career, you actually know how to do that. So I would love you to talk a little bit more about what you're thinking in terms of how you would evaluate, are kids really coming out at the other end of a program in a way that shows, is there a way to measure that they're actually served and their behaviors or conditions are improved?
Absolutely. And that was the benefit of taking a break from Maryland State Service is I got to go out. I worked in 20 different states over 3 years and see how different states are doing. So I saw some good, some great, some, I don't know if I would want to bring that back here. But what I saw and what I helped implement in places is how do we have a real behavior change system? Not just a treatment system, but supporting behavior change, understanding where our young people are in their adolescent development and what can help them build skills to sustain that change over time. Right now, our treatment program is solely based on dosage hours. You get 100 hours, our staff is going to court and saying they got 100 hours, they're ready to go. And that's not enough. And we're seeing that. And the courts and stakeholders are questioning, but what are they done differently? What have you been seeing? What about their behaviors? They just had a big incident the other day, but you're still saying they're ready to go home. So we have to take that dosage and add in how we are observing behavior change, which means we have to take every opportunity that we work with a young person to teach, practice, and implement a skill, see how they are utilizing those skills day to day, understand how they can have the opportunity to even leverage them more. So we would see incidents go down. We would see their behaviors change. We would see them self-advocating. We would see them engaging in developing their reentry plan. So we're going to have an objective way to measure all that and put that dosage plus behavior change together. We hope, I was like yesterday, I would like that done, but I think realistically, we're probably about 6 months away.
Thank you.
Delegate Woods. And Delegate Woods is our juvenile subcommittee chair.
Thank you, Madam Chair, and also thank you, Madam Secretary. I have a concern that I will preface by saying you may not be able to answer in this time period, but I heard you talk about using AI for assessment, and that sets off my spider senses. I'm concerned about how we will address the individuality of the young people that are being assessed, given what was talked about earlier, the ACEs, also the context of the trauma and drama of, that some of the young people are experiencing. I'm always concerned that, AI can be biased, and would like to know what protections you are putting in place if you are actually going to consider utilizing AI for assessment.
So when I talked about that, I'm talking about assessing applicants to come work for us. Oh. We are not talking about utilizing that with young people, but I hear you. Like the AI is, I'm a lawyer. I'm learning as we go on all of this. We know we need to have protections in place. Governor Moore has put together a really great team to help us think through some of the implications of AI across the entire state government. But as it relates to those staff that we will be using an app or computer-assisted psychological evaluations, we are still having people involved. We will have a psychologist review them, a psychologist intervene if we think something doesn't look right, and for every psychological that comes up as they did not pass, we will do a secondary review to make sure there isn't bias or it wasn't how they just answered a question.
So thank you so much for the clarification, and you're absolutely correct. I would be concerned for the same thing with hiring of staff. Thank you so much.
Delegate McComas.
I guess, I know we're all into what do I want to say, figures, and so we spend this money and we're going to get this much outcome. But what I'm wondering is, and you have to realize, the children where they came from and where they're going. And so it's really important for like good role models for the kids, if they don't have it at home. And so I'm wondering is, CASA, there's that CASA program, for kids that are in foster care or going through, there's issues about the children and where they should stay. And not in the juvenile service, but would that be a good implementation to help the kids that are in the juvenile custody as opposed to the foster care system? In other words, to just have an advocate or a friend or somebody that, can kind of nurture them. Then the other thing is, are there recreation programs for the kids, because I know everybody said, oh, if they're playing sports, their grades go up. And then the other thing I knew, because it was always very important that there be programs when the soldiers are in the military for recreation and, whether it be movies or it's a recreation night, but special things that, make the kids feel like they're special as opposed to just it's the same old stuff. And I think the other thing is, do you have when children go into the juvenile justice system, do you have a good feel for where they came from their family? I mean, is there any social worker that does some work as to find out there's some chinks, you got an alcoholic in the family or there's drug addiction or the mother suffers from, okay, all right. And then the other question is role models. Do you ever get any people that the kids would be really excited, like a Cal Ripken to come in and sign somebody, you know what I'm saying? Or just, somebody that the kids can look up to, because I think if a kid's having trouble and they could just find somebody, hey, I want to be like that. That's good, not bad.
Right. Well, yeah, absolutely. We want to create exposure and opportunity for our young people across the board. And I think that's a lot of sort of at the baseline of what you're talking about. I've long loved the CASA program. I think it's so wonderful for our young people and our foster care child welfare system. And we can learn a lot from that program, especially as we are thinking through how do we support our young people, especially those who leave us without connection, right? Who don't have a case manager, who don't get a social worker, who aren't going to long-term treatment. Good portion of our kids are leaving without that sort of connection. So we need to build it. And I think CASA is a place where we can learn on how we can build those effective relationships because it's about navigating, connecting, and supporting rather than compliance and surveillance. Recreation programs, we try to bring that into our facilities as much as possible, and we've expanded quite a bit. We had some roller skating. Our young people will try out skiing, they go canoeing and fishing. And again, it's about exposure and opportunity. We want to expose our young people to new and different things, and that might be the thing, right? That really helps change that behavior over time. And the more we can throw out there, the more we will build those connections. So yes, we are always looking at expanding our programming and recreation. We want to make sure we are connecting our young people to meaningful connectors. We have a Credible Messenger program where our young people can connect with credible messengers from their community to be able to help support them as they return home. And also, we're bringing in, like ROCA, a program in Baltimore City, into our facility to start working with kids in detention while they are there, so then when they go, they have a connection already built. So we're piloting at Baltimore City Juvenile Justice Center with ROCA coming in, building those connections. We hope them to go to Hickey next.
Thank you, Madam Chair.
You're welcome, Delegate McComas. Delegate Valentine.
Thank you, Madam Chair, and thank you, Madam Secretary, for coming in today. I had a question to follow up on the electronic monitoring when there's egregious circumstances where you have to detain an individual, a juvenile, until the next business day for court or whenever that may be, if it's 3 days, if it's a weekend. Can you walk me through that process? And I'm really trying to consider Western Maryland in particular. Are there locations throughout the state in which these juveniles can be placed so that if something were to occur in, say, Cumberland or Hagerstown, are these juveniles being transported a great distance, like 100 miles or 200 miles, or you try to keep it as close as possible? I'm just trying to see if a child from Cumberland is going to be placed in Central Maryland.
I mean, sometimes the Eastern Shore. And that's the reality of it. You know, there were some decisions made on how we utilize our facilities before I came here. And so our Western Maryland detention facility is primarily for girls now. It used to be for boys. And I think as we look at how we have a continuum of residential facilities, we know kids are coming from all around the state. We know we want to keep them closer to home. We're sort of rethinking how we can use what we have to best serve our young people. I would expect some changes over the next 6 months as to how we're utilizing our facilities.
And my last part of that question is simply, who conducts those transport? Is that law enforcement, DJS personnel? I know you're short-staffed. Is that a vendor, or how are these children being transported across the state?
All the above.
Okay.
And so if it's just a pure arrest, say law enforcement intervenes in a situation and they just arrest a young person, they're going to pick that young person up and transport them most usually to the nearest facility, and then we will relay. DJS then will relay. So you're in Cumberland, they can get them to Western Maryland Children's Center. We'll generally relay somewhere else, either Hickey, the city, or Cheltenham. But even our community detention workers, if they are intercepting a young person who's in violation of community detention, they might pick them up and drive them over. So it's a sort of an all-hands-on-deck approach.
Understood. Thank you. Thank you, Madam Chair.
Sure. So Delegate Mangione, I was going to say we have no more questions because I'm saving my questions for last. But Delegate Mangione.
Thank you, Madam Chair. And just a quick question. Thank you for being here, Madam Secretary. The 2025 audit that came out revealed that a rather, I guess, shady individual with prior convictions for second-degree assault and possession of a weapon was hired. I'm not saying this had anything to do with you, it's prior, but this individual was allowed to work obviously around juveniles. So what is the agency doing to prevent something like this from happening again in the future?
So there's sort of two different pathways. One is if our staff member is working directly with young people, they have to be MPCTC certified, Maryland Police and Correctional Training Commission certified. They look at the record. You really can't have anything on your record and be a residential advisor or community caseworker. Now, if there is something that's there, then that individual or the agency can appeal to the commission, and the commission makes a decision on whether or not to waive some of the requirements that would allow them to work with young people. So there's a lot of oversight there. The other pathway is then everyone else who works at the department. We require background checks, and we are in the process right now of working internally to revise our background check policy and practice to make sure all the I's are dotted and the T's are crossed. We want to create opportunity for people who may have been involved in the system to work with our young people when it's appropriate and when it's safe and when we thoroughly vetted it.
And thank you. I think it was a contractor, so I guess it was
and that's probably the third pathway. That's also then applying those policies to our contractors. Yeah. And I know it was a big issue in the audit, and we are working with our auditing team statewide, our legislative auditing team, and our internal auditing team to get to a place where we all feel confident that that policy is in the best place.
Thank you.
Great, thank you. So I have a couple questions. Some of my colleagues have already asked some of them. I thought Delegate McComas was going to ask about the PETS program. Did you hear that question earlier?
I did. We had a PETS program.
Yeah. And I think there's some merit there and something to think about. I mean, I don't know what the cost would be, and I know cost is a factor. But if it's something that perhaps, you could implement, I think there is some merit there. One thing that was in the audit, well, what was in the Ombudsman's report was about weekend activities are not utilizing much with respect to the weekend. Can you address that? If there are any, I'm sure there are some, but I mean, what has been done to improve the downtime over the weekend?
So we have a dedicated staff person who's helping curate and implement that programming, not just like in the evenings. We have, they're pretty busy. Each day they go to school for 6 hours a day and then have treatment if they're in their treatment programs. But detention, we do have a gap of time. And then those weekend times, it's tough to fill. So we've also created toolkits for staff. So it's not like they were asking staff to come up with the game or the activity. We put a toolkit together so they have some things available to them. So they don't have to really sort of put all the, some people are really good at that, others aren't. And so we want to just put it right in front of our staff so they have it available to them. But also expanding opportunities to even go on and off campus where appropriate, to have people come into campus. Senator McCray has come out to, I think, 3 of our facilities in the past few months talking about apprenticeships, bringing in new people, and also just expanding access and programming. So we can get you a bit more specifics around that and an example of what we would do over a weekend.
That's great, because Waxter was, very near and in my district when it was open. And I went over there and did some guest speaking, and I thought it was good. I was surprised. I was going to ask Delegate Valentine this question, but then I realized I could just look it up myself. And so I was very surprised to learn, I didn't realize we had 20 major military installations in our state. So with that said, I wanted to know if we have any relationship or collaboration with any of those 20 military installations.
So I learned over Veterans Day, when I attended our Veterans Day ceremony, our Deputy Secretary of Support Services is a veteran, and this is an issue that's very near and dear to heart, to create opportunities for young people to connect to our service, armed services if they want and they see it appropriate. So we have a junior ROTC program that we are bringing on board, and other activities, which again, I will follow up with her. She's done more than I'm gonna be able to give credit to right now. So when we give you that example of weekend programming, we'll add in what we are doing to connect our young people to the services.
Great, and inviting them as guest speakers would be great too, I think.
Yes.
The other thing is, as a recommendation, if you don't have it already, I've done some playing around with the dashboard, but if you could also give some reporting with respect to the programs. Yeah, that would be helpful.
Yeah, we have again, not the easiest thing to navigate, but a comprehensive overview of all the programs that we utilize, residential and those that we have community-based contracts with, and everything they do and everyone they serve. And it's on the website. It gets updated yearly, but as soon as we got that dashboard up and launched and operating, I got back together with my IT team, who worked all over holiday break to get this thing ready to go on January 1. And I was like, so who's ready to start on version 2? And so that will be part of hopefully what we can add in on version 2.
Great, because we know that programs work.
Yes.
So we need to be able to see programs that are, how many children are able to utilize the benefit of programs, and just how they're used, and how we could probably determine how they help with some level of recidivism as well. The other thing is, I wanted to ask the same question that I asked Madam Ombudsman, Madam Secretary, and that is with respect to the frequency of meetings between you or someone on your staff and the OCO or someone on staff, because I think there's a level of intentionality that you bring, having all the experience, and I think there's a level of intentionality that the ombudsman brings, because they're actually there and they're doing this monitoring. So I would like to encourage more frequency of that, and I'd also like to encourage some level of true follow-up and charting of this is, I'm a very visual thinker, so this is what I have in mind. Something of, a chart that says this was the problem, and then there was like a quarterly review or whatever type of review, and this is how it was fixed. And I'm not talking in a narrative. I'm actually speaking more in lines of something that one can actually look at and feel like you've gotten things accomplished. And I know you very much have gotten things accomplished, but we all can use a level of improvement. And what I heard from the ombudsman, and I'm not trying to take words out of her mouth, but what I did hear was, these are some very old problems that have existed. Some of them are some very old problems that have existed prior to you coming on board. And I know, and I believe you've only been on board for 6 months. Is that right?
6 months.
Yeah, about that. So there's been a lot that has been accomplished, and that is good. but we want to continue this trend and even do more. And I think we can. And so I think, and I honestly believe you get it done when you can, because we never know how long we're going to be, anywhere. So we always want to make sure we get as much done as fast as we can, especially when it comes to children. I know you have their interest at heart, but I just want to encourage that frequency and that intentionality, and especially that level of collaboration.
Yes.
Okay, there you go. All righty. Thank you so much. Okay, this ends the briefing of the Judiciary Committee for January 22nd, 2026.